because we put your notepads and stuff back on your seats. And y'all can be seated. So I wanted y'all to come out to be able to grab your notes, but if you do have phones or anything, electronic devices or anything that would communicate with the outside world, make sure you leave them on your chairs here. And with that, good morning, everyone. Good to see everybody. Hopefully everybody got a good night rest after last night. But we'll go ahead and get you back, continue your deliberations. But like I said, if you have phones, leave them here on your chairs. And you can take your notes with you. Discuss your issue, go over to courtroom B. Madam Court Reporter, you can go over to courtroom B, just counsel and the court reporter, and I guess a client or party reps.
Your Honor, quickly before we do that, I just saw the bailiff take back 2 white binders.
What were the other?
Exhibits were in 2 black binders, and I just wanted to make sure that they had access, the jury had access to defendants.
That was the first.
Oh, you did? I'm sorry.
I didn't hear it all.
I may have missed it. I apologize. I just wanted to make sure. Thank you.
All right, so they got all the exhibits. So for the record, bailiff indicated, yes, all the exhibits were brought back there. And they also, I think with the first round, you had the jury instructions and the form, the verdict form.
Thank you, Your Honor.
Okay. All right. So counsel and the plaintiff or defense rep and the court reporter will go over to courtroom B, and we'll do it over there.
Okay.
Okay. just sent out a note that said, calculator, tissues, water, please, thank you. So we got the calculator that had gone back, and we got a box of tissues.
Water.
Was there water here that we can send back?
I can go downstairs, there's a vending machine, right?
There was no more water in there approved. I gave it all to him.
I'll go buy 6 bottles.
Okay. All right.
There's a drink machine right around the corner over here on this floor.
No, it's broken. All right, I'll be back with water.
All right, so just for the record, I'm sending the calculator and tissues back without objection. Mr. Friedman's getting some water to bring up. last night this morning at 5:51, the plaintiffs filed a motion in limine regarding the defense expert on phase 2. And I've had an opportunity, when I got here this morning, to read the motion. I haven't read the depo transcript or even looked at the expert report that was attached to the motion. I'm willing to hear argument. Obviously, y'all just got this 4 hours ago. Is defense ready to argue this issue? I mean, obviously, we need to do it somewhat in a timely manner to be able to address if we need to move to phase 2. But
We are, Your Honor.
you are? Okay.
And for the record, Paul Safier, Safier, will be handling it for CNN.
All right. And you, Mr. Freeman, you had indicated Mr. Delich was the one that had worked on this.
Yes, and he told me before we went to court this morning that as soon as we knew when, we should let him know.
Okay. All right. Well, can you get him over here, and I guess we'll address this now?
Yes.
Yeah. All right. Let's wait till Mr. Delich gets here, and we can move forward with that.
Is there anything else Your Honor would like to take up? If there's not, I was going to step outside and just make some calls.
Well, I was going to ask you all if there was anything else we need to take up. So.
Or nothing from defendant.
All right. Mr. Roach, you got anything else on the plaintiff's side for right now?
Nothing right now.
All right. Well, then, we'll wait till Mr. Delich gets here, and we can address that. I'll try to plow through this a little bit more, but obviously I'll probably need to look at some of this, but I'll hear the motion.
Thank you.
All right. The plaintiff's motion in limine regarding the defense expert, Anita Junaja. And as I indicated before you got here, Mr. Delich, obviously we just got filed this morning a few hours ago, and I had a chance to read through the motion real quick before coming up here, but I hadn't looked at the expert report or the depot transcript, but figured why don't we argue it, at least get the arguments on the record. I'm still going to need to review some of this stuff eventually, but at least be able to address it this morning. Okay.
Yes, Your Honor. Happy to do that. So we're moving to exclude Dr. Junaja on a few different grounds. I think it's first important to understand what her opinion is doing, and she's essentially a rebuttal expert to our expert, Mr. Johnson. And Mr. Johnson took a look at CNN's, financial documents and said, as of today, here's what I think about CNN's financial condition. Dr. Junaja's opinion kind of boils down to, well, he should have also accounted for the fact that some of his inputs were kind of stale, they were kind of old, they're from 2023, and he should have accounted for the fact that in media there's these negative industry trends. And that's basically the extent of the opinion that she's offering. There's just a few problems with it and why it should not be presented to the jury. So the first is with respect to the negative industry trends. Dr. Junaja is not a media industry expert. She's just not qualified to opine on, the trends in the industry. There's even a media practice group at her firm. She's not a part of it. And so we don't think for that component of it that she's qualified to be offering an opinion about, what the future holds for cable news networks.
Yes, to interrupt since I'm doing it. Can an expert, though, if they're opining, in some sort of valuation aspect, can't they, even if they don't work in a particular industry, can't they review and consider things that are related to that industry? If there are studies, if there are reports, if there are things that would pertain to the industry, can't they rely on that even if they aren't? They're an expert on valuation issues. They're not an expert on the industry. Can't they rely on industry stuff, though, to crank into, just like any other assumption? We had, for instance, Mr. Balco, he may not be in the security or consulting business, but he can go and rely on facts and figures for purposes of some of his assumptions, can he?
Yeah, I think as a general matter, yes, Your Honor. I think the problem with Dr. Junaja's opinion, though, is it's looking at things like there's a decline in network subscribers, right? And I just don't really know that she's qualified to then translate that. Like, what does that mean for CNN as a company's financial condition? I don't think she's in a position to say what the significance of that is necessarily to CNN's business. She doesn't opine at all on the digital component of CNN's business. And you're just looking and saying, oh, there's some negative trends in an industry, that's a thing that exists. The jury could do that too. I just don't really understand what she would be offering, that a jury would not be able to get from that same information. She's not able to apply it in any way to the financial condition of the company because she's not an expert in media companies and how they monetize and how that's related to, say, how that, in detail, obviously there's, sort of broad, high-level correlations between things like the number of subscribers and the profitability of a company, I assume. But, in terms of actually providing informative analysis, I just don't think she's has the qualifications to do that. I think, and this kind of bleeds into the next point, which is that the data that she's using to do this is unreliable. She has, let me see, I noticed that the Kagan report, I think it's something that's put out by S&P, S&P something. But so there's kind of two problems with using that data to talk about the industry trends here. And this kind of gets back to the notion of like her lacking the qualifications, right? Because she finds this data set, and the data set on its face says, this report and financial metrics here are estimates and projections with portions based upon data from the Nielsen Company. The information was obtained from various sources which we believe to be reliable, but we do not guarantee its accuracy or completeness. Opinions and projections contained in this report are the opinions and conclusion of Kagan based on the data available to it and not intended to be statements of fact. So all of the data she relied on, we only sent in one example, Your Honor, with a little disclaimer here. Every single tab in the spreadsheet of this data she relied on has that disclaimer.
Where in the report or any of this stuff is that the reference that you were just reading?
So I think that disclaimer does not appear in the report. It appears in some of the data the spreadsheet that she's relying upon. The data appears in her report anytime she's talking about industry trends. Anything she talks about what's going on in the cable news industry, it comes from that Kagan data. All of which bears that disclaimer that says, this is opinion, this is not a statement of fact. And I'll also note, it kind of describes its methodology sort of at a high level. It says, we got some of it from Nielsen and other industry sources. And when we deposed Dr. Janasia about, what is this data, where does it come from, she was able to describe it at a sort of high level generality. She's like, well, lots of places. I understand that they go and they talk to people in the industry. I don't know who. She just doesn't really have sufficient information about the data that she's relying upon to incorporate into her methodology. If she understood in more detail the methodology that Kagan was using to put this together, like the specific, it's one thing to say they talk to people and they get Nielsen ratings at a general level, right? But she's using specific data sets and she doesn't know what's going into that set of data. And when she can't explain the specific methodology that was used for that specific part of the data set, not only does she not know what's going into it, she doesn't even know precisely the methodology that was used to compile that particular data set together. And then she takes that and she bases her opinion entirely upon that. And so we think, again, it kind of dovetails a little bit with the qualifications issue, but you have this unreliable data going into a methodology that then I think she has limited qualifications to then translate into the financial implications for the company.
I don't know that I understood or got what you were. I see a number of footnotes in here saying, we data's from Kagan with portions of data sourced from Nielsen, but you referenced something that sounded like a specific disclaimer that's saying this is not guaranteeing the reliability of the information. Is that in the Kagan report?
Yes, Your Honor. It's in the Kagan data that's being cited by the report.
Okay, but the Kagan data, other than what was incorporated into this report for Janasia, is there anything in your motion or attached to your motion that includes that disclaimer language from Kagan, the Kagan data or the Kagan report?
There was supposed to be, Your Honor. Let me... Yeah,
because that's what I was asking for. Where are you reading that from, that it talks about the lack of reliability, supposedly?
So if you go, our filing came in as I think one PDF. If you go to the last page, page 98, we just printed out one portion of the spreadsheet. It's a spreadsheet with multiple tabs and a lot of rows and a lot of columns and years. But we just tried to print out the relevant portion here because we think that is the disclaimer, which applies to the entire data set, every single tab, every single sheet.
Okay. Where would one obtain this Kagan report or Kagan data from? Is it available publicly?
It is not, Your Honor. It's a subscription service. I believe Mr. Safer can maybe confirm. But if Your Honor would like the actual Excel file, we're happy we can email it to the court so you can review it in its entirety.
All right, Mr. Safer, do you have access or?
Yeah, my understanding is it's a subscription database. Anyone can purchase a subscription, but it has to be purchased, and we provided opposing counsel with the Kagan data on which she relied.
Okay, as part of her, Mr. Janasia's file in the case?
That's correct, Your Honor.
Okay. All right, yeah, if y'all have it and you can email it to my assistant, that'd be great.
Yes,
Either
yes, Your
one
Honor.
or the other side, either side.
Yes, Your Honor.
We'll work that out.
Okay.
Okay. All right, may I proceed?
Yeah, go ahead, Mr. Delich.
So, and that kind of brings me to my last point, and really what's my main point, which is that Dr. Janeja's testimony is not going to be helpful to the jury. And that's the most important thing, really, when looking at whether an expert should be allowed to testify to the jury and put their imprimatur of legitimacy and expertise onto whatever it is that they're saying. And her testimony, because of the nature of her report, she's not offering any numbers, any financial numbers about CNN. She's not saying that any of the numbers that Mr. Johnson put in his report are wrong. She agrees that they are all accurate. She takes issue with his statement that it is... that he has that appears to be a financially stable company, and he sees nothing that says it won't be able to meet future financial obligations. That's kind of the statement that she hones in on in Mr. Johnson's report. She agrees with all of his numbers, and with that statement, what she's saying is, she's like, well, you can't just say that because what you did just used the financial documents that CNN produced to you. And turns out that the documents that CNN produced to you, well, they're a year old. And so you're using year-old documents, and you should have done something different. I don't know what you should have done different, but you should have done something different that acknowledges that the data that CNN gave you is a year old. Doesn't say what, doesn't say how it should affect or make his opinion different. She just says he should have done something. And it's the same with the industry trends. Now, you can kind of assume that she thinks that the negative industry trends should be reflected in Mr. Johnson's statement to have some sort of more negative forecasting put into it. Like maybe it won't be able to meet its obligations. First of all, she doesn't say that. It sort of seems to be implied. But there's just a few problems with it. One, again, she doesn't say what he was supposed to do, Your Honor. She doesn't say, oh, take this Kagan data. I have this Kagan data that says subscribers to CNN are projected to go down 30% in the next 5 years. So that means that Mr. Johnson should have, she never fills in these blanks. She just says you should have done something. And that's not helpful to the jury. The jury can't use that information to do anything. And I think that the other problem with that opinion of hers is what's relevant to the jury is CNN's financial condition today, right? It's condition today. Not tomorrow, not next week, not a month from now, certainly not 5 years from now, 10 years from now. The verdict is, if there's a verdict, will come in today, and this will be the day the jury has to assess CNN's financial resources, its ability to pay, the limits on its ability to pay, and there's just really no place to be going, well, maybe in 10 years, negative industry trends will have somehow affected CNN. It just doesn't have any relevance to what their financial condition is today, and that's the limit of Mr. Johnson's opinion. He's not talking about how solvent they're going to be a decade from now. He's talking about their financial condition today based on the most current information that he was provided by CNN. And so, it's just, her opinion is not helpful to the jury. And to the extent that there's limits because of the age range of the data, I think that is self-created by CNN. And more importantly, she doesn't say what you're supposed to do with that fact. I think opposing counsel can tell the jury, well, Mr. Johnson used tax returns that are a year old. What do you think about that? He should probably should have accounted for that. Opposing counsel can argue that. They can ask Mr. Johnson about it. But I just don't see how Dr. Janeja coming up and saying it is going to give the jury any information to come to a more informed decision.
Okay.
And I think, unless your Honor has questions, I think that's it for me.
All right. I think that satisfies my questions for right now. I may have more, but thank you, Mr. Delich.
Yes, Your Honor.
Mr. Sapier.
So, Your Honor, as you noted on the record, this was filed at 5:50 this morning, something, so I haven't had a ton of time. And I will say, and this is to segue into my next point, I'm not sure why this had to be filed this morning. Nothing new has happened during the trial. The arguments Mr. Delich made track very closely to the deposition he took of Dr. Janeja on January 2nd. And that bleeds into my next point, which is that, and I suspect you will anticipate this. The points Mr. Delich makes are perfectly fine fodder for cross-examination. He can ask Dr. Janeja about whether she's a media expert. He can ask her about the Kagan data and what she knows about it. He can ask her about, you're talking about future trends or trends from the past that you're extending out. What is the significance of those trends? What should the jury do with it? He can ask all that. It's not fodder for a Daubert motion. So that's kind of our big picture point. I want to just level set a little bit to explain what Dr. Janeja does, at least from our perspective. There's sort of two things she does in her report. The first, which I don't think came out in the motion or the analysis, is she says Mr. Johnson relied on various financial documents that he then produced. His math was accurate. I'm not disputing his numbers in the sense that the documents he relied on say what he says they say. I just think those numbers, and she's saying this is what she's been testifying, the numbers don't show what Mr. Johnson says they show. And to use one example, the tax documents he relied on, for instance, for CNN Inc., don't incorporate certain corporate level or WBD level expenses that would have to be taken into account in getting a full, complete picture of CNN Inc. So that's sort of one piece that she's testifying to. That doesn't relate to the Kagan data, doesn't relate to the future trends. The other thing she's saying is if you look at both the Kagan data and CNN's financials, you're going to see that CNN in particular and the cable industry more generally is facing a tough economic environment. Those of us who follow this know something about this, right? And she's going to say that's borne out both in the data from Kagan and the financial data that CNN produced, both CNN Worldwide and CNN Inc. And that's relevant to what the jury's doing here for two reasons. It's relevant first because the data on which Mr. Johnson relied is 2023 data. So if we're projecting to today, we would take that into account. I want to make one point about the completeness of what we produced. But the other point she's saying is I understand this exercise that the jury might be asked to undertake at phase 2. They want to understand enough about the financial condition and financial health, to use Mr. Johnson's term, of CNN to know what effect a punitive damages judgment would have on CNN. To understand that fully, you have to understand what's happening in the industry, what sort of economic trends they're facing, what in general is happening in their world. And what she will say is, look, given the sort of difficult environment in which cable news is operating in, a judgment's going to hurt, right? A punitive damages judgment is going to hit them hard in a way it might not if these trends didn't exist. And the more sort of other point, one of the things Mr. Delich said is, what the jury will determine at phase 2, if there is one, is what the financial condition is today. Well, Dr. Janeja, who will testify, to understand sort of your financial condition today, you have to know events, have some sense of what's happening in the future. Do I have retirement money? Am I going to inherit money from someone? Do I have this gigantic debt obligation in the future? So that gives you a sense of what Dr. Janeja intends to testify to. And with that, if you have questions about that, I want to address the specific points, but that's sort of the big picture account of what.
Yeah, well, I mean, as far as trending goes, I mean, most of the time, I could think of a small business that could walk in today and pop out its financial picture, a balance sheet as of today, a profit and loss as of today, even though, most of the time, obviously, you're reporting stuff on a annualized basis, whatever your reporting year is, your tax year may be, and things of that nature. Obviously, tax returns are a snapshot as of December 31st or whatever your calendar year is, of that particular year. So in the course of litigation, we do discovery, you get records, but obviously they're dated as of whatever the current time or date is for production of those things. To the extent that there may have been some trending difference between when the documents were prepared, in this case you're saying they're 2023 data, which would have been the last year end. I know we've had a ton of hearings over various and sundry discovery issues here, but there was quarterly reporting supposedly that was available as of at least a few months ago that we were talking about and stuff like that at a prior hearing. What I'm getting to is I understand whatever date the documents, the data is produced as of for the financial picture versus today, there could be some discussion if obviously the relevant inquiry is what's the financial condition, the financial health or whatever of the defendant as of today. Why would trending after today be a relevant issue?
2 points.
Not be either prejudicially suggestive of, hey, we're going down, so hit us less today because the trend says we're going to be even worse condition in a year from now. Absent and irrelevant to this lawsuit, where you're sort of improperly suggesting a potential lower number to a jury for consideration. Why would we care about trending after January 2025?
2 points. 1 point on the documents. We did, as I think you alluded to, we did produce for CNN Worldwide quarterly financials through to the third quarter of 2024. Mr. Johnson, I deposed him about it. He didn't look at those numbers or didn't use them. So there were numbers, and we hire experts because they can do things. Mrs. Bolko made quite ambitious projections into the future. So we did provide 2024 data that an expert could have used to say things about 2024. Mr. Johnson, for whatever reason, did not. That's the first point. But the second point is one of the things the jury is being asked to do is the basic exercise of phase 2 is, punish but not bankrupt. And the first part of that, the punish part, is you need to understand financially what the defendant is dealing with to understand the impact of your judgment. And I think it is perfectly appropriate to say to the jury, look, going back to 2018, you have these trends in the cable industry. That's reflected in the Kagan data. That's reflected in the CNN data. CNN is operating in a tougher environment now than it was in 2018, in 2020. That means the judgment you issue today, if we have a phase 2, is going to hit them differently than it would if the trends were otherwise. That's a perfectly appropriate argument to make at the phase 2. And Dr. Today's analysis supports that argument.
Yeah, the first part of what you were saying is they got quarterly stuff through Q3 of 24, and he didn't rely on it. That's a fair criticism of what the assumptions and data that was relied upon for the opinion. I think that's a fair criticism, and we address that in the context of Mr. Bolko and everybody else. But your argument more on the considering past January of 2025 and the trending is more to the second aspect of it's there to punish but not bankrupt. Is that
Correct.
What you were saying?
The first part, sort of understanding what punishment would mean in this context. And just
Okay.
a general proposition, what your financial condition is going to look like down the line is relevant to what you can do in the present. We all know that. If I'm going to retire next week, my life is very different than if I'm not going to retire next week. If I'm going to have this big payment due in 2 years, my life is very different than if I don't have this big payment due. So it's relevant, and they can cross-examine her about that. She testified about her deposition. Mr. Delich discussed that subject. You want to get in? Those are the big picture points. Do you want me to discuss the specific criticisms?
Yeah. Why don't you address those?
Right. As for her qualifications, she is a very experienced, Harvard-trained, 40 years in the industry financial economist. She spends her life going industry by industry by industry and offering her analysis of the financial health of a specific company, the fairness of a merger proposal. She's antitrust work. She's done some work in the media industry. She's not a media expert per se in the sense that that's not her specialty, but she has broad and extensive expertise in financial economics, which she applies to tons of different sectors and industries and has for 40 years. So I don't, especially given how low the standard is. I got this motion late, so I didn't do research, but I think she exceeds it pretty profoundly. On the Kagan data, there's standard disclaimer language in the Kagan data, which you're going to find in any data set you get from S&P. That's sort of a legal disclaimer saying that if you go and invest on this advice, you need to keep in mind that I'm not guaranteeing it. But the Kagan data, and she will testify to this and lay a foundation to this is data that's considered the gold standard among people who look at financial and viewership metrics in the media industry. People pay a lot of money to have access to this database. They're not going to pay that money if it's completely unreliable. She can testify that it's her understanding, both from her own work and people she spoke to who have more experience in media than she does, that the Kagan data is the gold standard. In addition, she backstops her analysis of the Kagan data with the CNN financial data. The Kagan data is showing this about advertising revenue, and lo and behold, if you look at the CNN actuals, it's showing the same directional trends, so she does that. That's the Kagan data. As to the point that her testimony won't assist the jury, this sort of goes to some extent to what we were talking about earlier. One of the points Mr. Delish made is she agrees with Mr. Johnson's numbers. What she testified to is he accurately got the numbers of the documents, but those documents don't give you a full, complete picture, including because the tax documents don't include the corporate expense allocations that have to be factored in, and she testified to that. And because that you would have to take into account broadly what's happening in the industry. What Mr. Johnson purports to do, it's on the first page of his report, is give you an assessment of the financial health of CNN. She disagrees with whether the documents that Mr. Johnson uses can give you that. She provides additional context, and that's a perfectly appropriate thing for an expert to do. Mr. Delish repeatedly said, well, she doesn't tell Mr. Johnson what he should have done. That's not her job. It's not peer review. What she's job is to do is to tell it to the jury. He gives you these numbers. Here's the full context for understanding these numbers. That's perfectly appropriate for a rebuttal expert. If she sat down with Mr. Johnson at peer review setting, she'd say, well, you could have done this, you could have done that, you could have done that. But neither party is going to testify to the jury about methodological issues, about how to what Johnson should have done. All she is required to do as a rebuttal expert is say, this is the limit of what the numbers he used can tell you, and this is the broader context. If you want to understand, as Mr. Johnson reported, to help them understand the financial health of CNN.
Yeah, and I think I said earlier, criticizing what you may or may not have, the ingredients you threw into your recipe to go bake your cake, well, you should have flavored it with this, or you should have left this out, or what have you. I mean, I think that in the normal context is a fair criticism. The fact that she's not offering a number, and she just said he screwed up, I mean, is it helpful? I mean, where she's not saying what the impact would be, his numbers, he screwed it up because he didn't take this into consideration. But what does that mean? I mean, is there a problem with her testimony not necessarily being helpful because it kind of doesn't lead to it may have no effect on his opinion, or it means his opinion is 2 times overstated? I mean, is there an issue with kind of going that next step of, he did this wrong, but it may be irrelevant at the end of the day? I mean, or it is relevant because what? X.
I mean, that's perfectly appropriate fodder for cross-examination or closing argument. One of the things that Mr. Johnson said when I deposed him is he said, financial health is a complex thing. You can't look at any one number. You can't look at any one metric. I kept on asking you, is this the number you like? Is this your favorite number? He says it's a complex thing. You have to look at a bunch of things. And that's really all Dr. Janeja is saying. You have to look at a bunch of things in addition to what Mr. Johnson looked at. You have to look at the corporate expense allocations, which undermine the numbers. And you have to look at the broad financial environment in which it's operating. Mr. Johnson himself does not purport to say, I calculated this one number, that's all I'm giving you, this is the gospel number. He's saying, I'm giving you a holistic view of CNN's current ability, financial condition, based on a bunch of different numbers and different documents. And given that that's the framing, Dr. Janeja is certainly entitled to say, and give some more context that the jury should consider. And this isn't, and I would again stress the nature of this exercise, this isn't like compensatory damages where you're saying, this is the number, the jury asks for a calculator, they do what they do. It's not an exercise with that level of precision. It's a sort of big picture. This is generally sort of what we're dealing with the defendant's financial resources. That's how Johnson approaches the exercise, and it's perfectly appropriate for Dr. Janeja to approach the exercise that way as well.
Okay. All right. Anything else, Mr. Safier?
Not at this moment, Your Honor.
All right. Village.
Yes, Your Honor. So a few points. So my first is there's some talk about Mr. Johnson relied on these tax documentation that end in 2023, and there's more recent stuff in 2024. It's not exactly accurate. So as Your Honor may recall, that one of the big issues has been, things for CNN Worldwide versus CNN Inc. versus, whatever other thing there is. The defendant in this case is CNN Inc. It is not a reporting entity or reporting fiction that a series of companies headquartered under Warner Brothers Discovery use to run collectively as a business. The defendant in this case is CNN Inc. And so documents, the most recent documents that we have for CNN Inc. are these tax documents that end at the end of 2023. And one of the problems, we didn't really get into it in our motion, but one of the problems, the additional problems with Dr. Janesia's opinion, is she's taken a bunch of financial information for something that nobody has been able to definitively define for me, Your Honor, called CNN Worldwide. I have asked the CFO, I asked Dr. Janesia, which legal entities contribute to the finances of CNN Worldwide. No one has been able to do that for me. They've been able to say, it's probably these, there's probably more, there's some that contribute in part, some that contribute all, but I've never really been told what's in it. I'm just told it's CNN's business. I can't sue CNN's business. I can't serve CNN's business. The defendant in this lawsuit is CNN Inc. We use the documents that they gave us for CNN Inc. We're not going to be allowed to use net worth information for Warner Brothers Discovery in this phase. I don't really understand why they should get to use a lot of information for a bunch of other companies that aren't defendants either from CNN Worldwide. So in terms of the corporate expense allocations, those are for CNN Worldwide, not CNN Inc., who's the defendant in this case. Mr. Safier mentioned, your health today is relevant, your retirement in the future is relevant. Yeah, to the extent that there's money in your retirement account today, right? If I have a bill that comes in, I have to pay rent for $5,000 a month or whatever. I'm in Manhattan, it's a very expensive apartment. I've got $2,000 in my bank account. I can't make rent. It doesn't matter if I got a rich uncle who wants to leave me a bunch of money 10 years from now. I can't make rent. I'm insolvent. I have a bill that's due, and I don't have enough money to pay it. Similarly, if I have $10,000 in my bank account, and I have a bill come due for $5,000, I can pay it. I'm solvent. It doesn't matter that I might go gamble in Las Vegas 5 years ago and lose all my money. It's just not relevant to the inquiry that we're trying to figure out. There's this notion that if you don't take into account the industry trends, you don't really realize that a judgment might hit CNN harder than it would otherwise, but for the industry trends. A judgment always hurts. That's, in fact, for the punitive judgment, that's the whole point. It's supposed to hurt. And you can't just say, well, maybe we'll lose money in the future and we'll be even worse off if you do this judgment. Maybe you'll win the lottery. Can we put in evidence that says maybe the CEO of CNN decides we're going to get into a new business, we're going to buy a bunch of Bitcoin, Bitcoin's going to go to $200,000, we're going to be the most profitable company in the history of the world, and I can tell this jury, for all we know, CNN is going to be the most profitable country in the history of the world 10 years from now. We should up the number. They would freak out, rightfully so. We got to be looking at the information that exists as of today, their ability to pay a judgment as of today, and not looking at what may or may not happen in the future. Mr. Safier mentioned, this question of bankrupting CNN. I've been told that my questions about, what would bankrupt CNN call for legal conclusions, and maybe they do. I do think the jury instructions say financially destroy, which I think is maybe the more appropriate inquiry for what they're doing. Dr. Janesia doesn't say what would financially destroy CNN. She doesn't know. Neither does Mr. Cohn. They don't have any information about that. I asked them. They have no information. They don't know. And so, Your Honor, it just comes back to, industry trends are not a resource. They're not a bill. They're not a liability. They're just kind of guesses about what's going to happen in the future. I also think to the extent that stuff exists, it's probably baked in various ways into CNN's current financials. I think a lot of the efficient market hypothesis stuff would suggest that, right? You would look at, hey, what kind of lines of credit do they have available, right? How big of loans are they able to take out? That's stuff that's available to them today. And that's factoring in, I assume, banks' kind of assessment of what CNN's going to be able to pay in the future and things like that. But I just don't see, I think Your Honor just hit it right on the head, coming in and being like, you should have done something different. But I'm not going to explain, I'm not saying that she should have done Mr. Johnson's work for him, but she's not even saying how he would have incorporated it into his assessment, and she's not saying what the impact of that would be. And, I asked Dr. Jadeja very specifically, are you saying that because of these industry trends, are you saying that there's anything to you that suggests that CNN is not able to meet a financial obligation today, as of today? She said no. She said no. She said maybe something will happen, maybe in the future, and maybe they won't. It's just not relevant to the analysis and the inquiry here that the jury is making, which is, what's going to hurt but not hurt too much. And you can't really be bringing in a lot of stuff that may or may not happen in the future. We should be looking at, first of all, the defendant, not a bunch of non-party defendants. And if we're going to bring in CN Worldwide, I really think we should reconsider whether parent company is appropriate to bring in as well. And I think we should be looking at the financial documentation as it exists today and not trying to make guesses about what may or may not happen in the future.
Aren't they, in defense, just the fact that she says plaintiff's expert didn't take into account these things, but without answering the question of, had he taken into account these things, the number would have been half X, instead of whatever he threw out. Aren't they doing that at their own peril, that they're not suggesting a number and, the jury's only got one number?
Maybe I still don't think it's helpful to the jury. And I do think it's very suggestive that we should be driving it down. I don't want to, a lot of this is under confidentiality. So
yeah, and that's, I don't want to get into specifics.
I'm not getting into specifics, but, there's an example where a revenue number goes down substantially from one year to another. Profitability goes up. Less money came in, but it was more profitable. Right? And so, the suggestion that, I don't know, we have less subscribers or whatever is going to impact our ability to pay, it's overly suggestive, it's unhelpful to the jury, and it's kind of a pity party, Your Honor, right? It's just saying, things aren't going well, and this is going to probably make things go worse, and it's going to keep getting worse. And it's not really what the jury's supposed to be looking at. They're supposed to be looking at, what can you afford and what can't you afford? And these guesses about the future just don't go to that. And so telling Mr. Johnson, saying, Mr. Johnson, you looked at what they could, seem to be able to do today, but you didn't consider all the possibilities of what might happen in the future. Why should he? Having an expert get up and say that, she doesn't really say what's wrong with it. She doesn't say why that means he's wrong. She doesn't even say that he's wrong. She just is like, I think you should have done it. Doesn't really explain why it's relevant to the company's ability to pay a judgment today. And I think that's where it becomes inappropriate, because you're putting the expertise on top of, well, he did something wrong and I went to Harvard, and so you should probably think less of what he's got to say. But she doesn't. She's just not offering anything that's actually helpful to the jury beyond that.
What's the methodology that your expert used to value it?
So he used, there's these tax forms, as you know, Your Honor, there's a lot of conflict over balance sheets, but there was these tax forms for CNN Inc. that have what is effectively a balance sheet. So, he looked at a number of different numbers, revenues, things like that, but the net worth number came from that, assets minus liabilities. It's a positive number. He says he sees nothing in the financials that indicate that it looks to him like a financially stable company that is currently able to meet its obligations, and that's it, and that's a true statement. There's no and he gives the kind of absolute what those numbers are. So the jury can try and figure out what might be enough to change that. But as of right now, he says they're solvent, they can pay their bills, and that's what I see in the financials. Dr. Jadeja doesn't disagree with that, and the industry trends don't change that.
You agree that they used a balance sheet valuation method?
I agree that the net worth numbers for CNN Inc. are pulled directly from the tax forms that include, as Mr. Delich said, was effectively a balance sheet. I wouldn't call it a method because literally the numbers are just taken from the document, but that's
But I mean, that's the methodology that their expert came up with for evaluation.
for the net worth number, yes. And Dr. Janasia will testify as why that isn't fully appropriate given the corporate level allocations. But
Parent company level allocations, Your Honor. That's what corporate level means.
right. Can I address a few points?
Yeah. Yeah, go ahead, Mr.
And
Saber.
if you don't,
No, it's just,
on the
and it may be what's cranked into, because I mean, a balance sheet valuation is you look at assets, you look at liabilities, you just figure out whether there's a positive or a minus. But I guess in terms of what they're considering assets, because my question is, I mean, you can value a business a number of different ways. I mean, I think we're all on the same page of that, correct?
Yes, sir.
I could see where industry trends may be relevant. Say I owned a commercial property. Obviously, I could value it just on going out and get comps and get a market analysis based on comps. I could also value it based on anticipated revenue streams, which a lot of times everybody says, well, the comps are premised on what somebody can make off of renting that property. But doing comps is you're just looking at comparable sales. This other one, you're looking at what is the rental rates and rates of return that you could have. And obviously, if I'm doing it based on a revenue stream, the trend, is the trend going down on revenue rates or is the trend going up on rental rates? Trending would be relevant from that standpoint as potentially for valuing it today because you're projecting a stream of income into the future and discounting it back on that basis. Whereas comps, if I'm just looking at value today, I'm looking at what a comparable sales were right around now. What are the most recent comparable sales if a willing buyer or willing seller out on a free market? But if they're doing a book value, you're looking at the value of assets as of a certain date, and you're looking at the amounts of the liabilities, and that's why I'm kind of wondering, is trending really even applicable to that sort of analysis?
The reason it is twofold. One, his numbers stop at 2023, and I appreciate that's because he relied on tax documents, and we don't have the 2023.
We hadn't filed 24 taxes yet, yeah.
The other reason it's relevant,
And we had this whole problem of they don't have internal running balance sheets and all the other crap we've argued before.
do you remember? I remember something about that.
Yeah.
A faint memory. The other issue is Mr. Johnson himself said, I'm looking at a bunch of different metrics. No one metric is right. In fact, he, in his deposition testimony, had a lot to say about net worth, doesn't think it's a great number, thinks it's easily manipulatable. So Mr. Johnson himself, if he were just saying, I did a book value analysis, this is number X as of today based on this document, I think the trend stuff is still relevant for reasons I've explained already and I want to elaborate on. But that would be a different story. But he's talking about a bunch of different metrics. In fact, testified at length that he doesn't think net worth is a very reliable metric in the context of evaluating financial health. I want to just make
Yeah, go ahead and your other.
a few additional points. Mr. Delich said, Johnson's core conclusion is that it's a financially stable company. Dr. Janasia doesn't disagree with that. That's right. But what Mr. Johnson does is say, as of today, CNN can meet its financial obligations. It's solvent. We agree. Dr. Janasia testified to that. What she testified further is, or no, what Mr. Johnson then said is, and if you want to know what the effect of what you're going to do today here is, look at this number, this number, this number. And her analysis comes in the second part, which is you need to provide more context to understand. But the threshold issue, if Mr. Johnson had stopped and just said, as of today, it's meeting all its bills. We don't know what new liability they're going to settle with today. So, that point is not the core or the essence of what Mr. Johnson testifies to. As to the CNN Worldwide issue, what Your Honor ruled at the Daubert stage with respect to WBD is it was inappropriate to bring WBD numbers in unless there was some way to sort of calculate a CNN-specific number from that. One of the things that Dr. Janasia can do is get from a CNN Worldwide number to a CNN Inc. number. She can sort of explain roughly the ratio of revenue, and she testified to that at her deposition. And the CNN Worldwide, as Your Honor knows, the CNN Worldwide financials are in the case not because, CNN Inc. is a smaller entity. CNN Worldwide numbers tend to be larger. It's simply because those are how the records are kept, and they asked for the records. We gave them the records we had. We could have sort of said, no, we're just giving you CNN Inc. stuff, and it would have been a much shorter period.
In terms of, I remember from the various hearings we've had, when you all got the request asking for information on the defense, what you offered was, we're giving you the CNN Worldwide. Is there any way to distill CNN Inc.? If they're just getting those records, instead of criticizing them and saying, hey, you use CNN Worldwide instead of CNN Inc. numbers, is there a way to distill it in what was produced to them of what is just allocated to CNN Inc., since you said there can be a difference and CNN Worldwide could be more?
Right. 2 points. One, we are not criticizing them for using CNN Worldwide numbers. The criticism goes the other direction, just to clarify. But Dr. Janasia did testify, and based on...
Well, and I'm not saying criticize, but is Dr. Janasia raising that issue that their number, she says they got the numbers right off the documents, but is she criticizing them on using CNN Worldwide numbers versus CNN Inc. numbers?
She is not.
Okay.
No, but there is a way, and Dr. Janasia testified this in her deposition, the revenue numbers in Mr. Johnson's report allow you to sort of back of the envelope calculate essentially what percentage of revenue for CNN Worldwide is CNN Inc. And you can make certain calculations based on that. Mr. Johnson did not do so. But
is there a way for him, if he just got the documents on CNN Worldwide, for him to look at them and say, okay, here's how I figure out CNN Inc.'s numbers from these documents?
Yes, because he also got CNN Inc. numbers that would allow him to, he could do things with it. He could create a ratio. He didn't do that, but that's something that would be easy to do based on the documents that were produced. I want to make one other point. One of the things that Mr. Delich said is, this is the punitive damages phase. It's supposed to cause you pain. Why are you saying this is going to cause us pain? The exercise that we're supposed to undertake in phase 2 is for the jury to understand in a nuanced way what the effect of what it's doing is going to be. And our point about the trends is that is part of that picture, right? It's not... there are a couple points about the trends, but that is a crucial part. And it's true both sort of in a common sense way, but it's also true sort of financially. One of the analogies that Mr. Delich made is, if I'm going to inherit money from my uncle in 5 years, that's not relevant to my ability to pay rent. You can do a lot. If you know you're inheriting a bunch of money in 5 years, you can actually do a lot in the present with that. So your future financial position is relevant to what you can do in the present. So that's just basic economics in terms of what you can borrow and what your calculations you make, what interest rates look different tomorrow. As a real estate developer, you deal with it differently. So it's just true as a basic matter of financial common sense that what's happening in the industry which you're operating is relevant to your financial health in the present.
All right. Anything else, Mr. Savior?
Not from me, Your
All
Honor.
right. Anything else, finally, Mr. Delich?
Yeah, just a couple. So you mentioned that Johnson's critical of the net worth figure, especially as a standalone number. That's true. He's still using book values, though, in terms of what he's saying, what else you should look at, right? He's saying you've got to look at the assets minus liabilities. You've got to look at the revenues. You should look at net income. He's saying you should look at all of these things and kind of consider all of them when assessing the current financial state of the company. He's not just like looking out into the ether for all sorts of things to influence the analysis. I also want to just clarify, it's Dr. Janasia that is criticizing us for using CNN Inc. financial information to assess the financial health of CNN Inc. What they want to do is that Warner Brothers Discovery has apparently decided to book some sort of expenses as a corporate allocation across CNN Worldwide, and they want to say, well, we should get to subtract that number. So you can't use other companies, you can't use Warner Brothers Discovery, but we got this negative number here for CNN Worldwide, which is, again, I don't know what it is, and you should have subtracted. CNN Worldwide is not a defendant. It's just not relevant. It's just not relevant. And I think I don't agree that it's super easy to take the CNN Worldwide documents we got and do a back of the envelope calculation and extract out what component of it is attributable to CNN Inc. No one can tell me what CNN Worldwide is. I don't understand how you can even have any sort of reliance on an exercise like that when no one can tell me what entities are even contributing to this reporting device called CNN Worldwide. I think maybe I gave the wrong impression with my uncle and inheritance example, right? I think if there's a will or there's a document where there's commitment, sure, maybe I can use that to get a loan. But what if I'm just I think my uncle really likes me. I think he really likes me, and he said, "Man, just don't worry, I got you in the future, right?" I can't do anything with that. No one's gonna give me a loan to make rent because I think something good is gonna happen to me in the future. I mean, it's just not relevant to the analysis, Your Honor.
I don't know. I think the will example is probably a bad example because your uncle could change his will tomorrow. When you piss him off, don't wash his car, take him to the doctor, do whatever he wanted to do. I mean, a better example of being able to crank it in probably would be if you did a quitclaim deed and already assigned the remainder interest to the individual, where you may not have the vested possessory right, but you've got a vested right that's already of record that you would have to, by virtue of you signing a deed, divest yourself of, versus you've got no vested interest as a beneficiary in a will. But anyway. Be that as a side, we're not going to delve into an entire different area of estate planning. And
taking us back to law school on this.
Let me ask you, Mr. Delich. I mean, I understand because of the timing, and we pushed back some of the expert disclosure stuff, and obviously the deposition past pretrial and past the other discovery cutoff deadlines, just from the standpoint of dealing with other issues that we had on some of this financial stuff. But if you deposed him, before we started trial, why are we getting a motion filed at 5:51 a.m. on the 10th day of trial?
Your Honor, to be honest, just been busy with the trial, I think we were also looking at whether we thought it was appropriate. I also think, we thought about moving orally, right, ahead of time, but thought that the paper would be helpful. I apologize for the lateness of the filing. I don't really have a good excuse other than trial counsel has been fairly occupied with the conduct of the trial.
Right. I mean, I understand you deposed him Thursday deposed her Thursday before we started trial, but do you have a copy of your expert's report you can shoot me?
Yeah,
or,
yes, Your Honor.
or paper copy or something? I'm fine with getting it emailed.
Do you have a preference? I have a paper copy.
Yeah, just show Mr. Savior.
I'll take this.
At least that'll be helpful to put it in some context for me.
And one thing, Your Honor, the report as handed to you includes a lot of information that's already been excluded. I assume that
It's already been-
information that has been excluded that I assume Mr. Johnson will not have to.
Yes, Your Honor. The current intention right now would be just the Cable News Network, Inc. component of the report, I believe.
So there were a few slides in the back, Your Honor. Related to WPD.
All right, we'd go through where it starts talking about WBD stuff.
Yes, Your Honor.
Those are not.
Yeah, page 2, and then the slides starting at, they're not numbered, but starting roughly halfway through when you have WBD numbers.
Did I? Did I sign an order on a motion in limine on this?
You did.
Okay. I thought I had, and there's been a few filings and orders in this case. But I remember I thought we had addressed it at a hearing anyway.
Yes, Your Honor. We're not disputing that the Warner Brothers discovery of material is excluded.
Okay.
And I'll also note, the slides as they were put in the report, we're kind of looking at both, if you look, for example, at the net operating income, you get a number on the left and a number on the right. And those reflect not so much a range, but CNN Inc. on the one side, and then his attempt to kind of do the same thing with the CNN, quote, worldwide documentation. However, I think at this point, our intent would be to present to the jury just information about the defendant in the case, CNN Inc.
All right. All right. Anything else?
I know.
No, Your Honor.
All right. Let me look at this, because obviously I hadn't gotten through Dr. Janae's full report and the depot yet, so I'll try to do that rather quickly, just from the standpoint of it won't hold up anything for us if we need to get to phase 2. All right. Anything else for now from anybody?
Just to the extent the court indicated it may come back with more questions, am I excused to go continue witness preparation, and I'll hurry back if I'm needed again?
Yeah, no, I mean on this. Oh, you're talking about on this?
Yes, Your Honor.
Yeah, I'm good.
Okay, thank you, Your Honor.
All right. Yeah, so go ahead and go back and do what you need to. All right. Anything else from the defense? All right.
Not at the moment, Your Honor.
All right. And we'll go off the record and. understand from a bailiff that we have a verdict. Let me get counsel to just come up to the side real quick. I don't need the court reporter. I don't need. All right. As I indicated, the jury has a verdict. Is there anything we need to address on the record before we bring the jurors back from the plaintiff for defense?
No, Your Honor. No, Your Honor.
All right. Then we'll get the jurors back in.
Jury Henry?
Y'all may be seated. I understand that the jury's reached a verdict. Is that correct?
Pardon me?
I said I understand y'all have reached a verdict.
We have.
All right. You have the verdict form with you?
I do.
Can you hand that to the bailiff, please?
I will.
ask the clerk to publish a verdict.
In the Circuit Court of the 14th Judicial Circuit in Fort Bay County, Florida, case number 22-608CA, Zachary Young, plaintiff versus Cable News Network, Inc., defendant. Verdict form number 1. Do you find by the greater weight of the evidence that defendant CNN committed defamation per se against plaintiff Zachary Young? Yes. Number 2, do you find by the greater weight of the evidence that defendant CNN committed defamation by implication against plaintiff Zachary Young? Yes. Number 3, what is the total amount of plaintiff Zachary Young's damages for both lost earnings in the past and for the loss of his earning capacity in the future, reduced by the amount that plaintiff could have earned from comparable employment? $4 million. Number 4, what is the total amount of plaintiff Zachary Young's damages for pain and suffering, mental anguish, inconvenience, injury to reputation, and loss of capacity for the enjoyment of life that he sustained in the past and that he has sustained for the future? $1 million. Number 5, do you find by clear and convincing evidence that punitive damages are warranted against defendant CNN? Yes. Date, January 17, 2025, signed by the foreperson.
Okay, yeah. All right. Juror 6, I take it since you were holding the verdict, were you the foreperson for the jury? Is that your jury's verdict?
Yes, it is.
All right. All right. Anything from the plaintiff?
No, Your Honor.
All right. Anything from the defense?
No, Your Honor.
All right. All right. Jurors, based upon that verdict, what that means is we need to proceed to phase 2 of the trial in this case. I didn't print them out, but let me pull them up real
Sorry,
quick.
Your Honor, I think I was supposed to stand up,
No,
wasn't I?
no, you're fine. You're good. All right. I've got some more instructions to give to you, and what we'll do is just based on the time at this point, we'll move into phase 2. We'll get some lunch brought in to allow you, to take a break to have some lunch at the appropriate time when it gets here, but we'll start with the presentation of some of the evidence and testimony to you until that point in time, okay? Are y'all good with that? All right, and I know since there was a restroom and stuff back there, y'all don't need a break or anything right at the moment, do you?
No, sir, but could we close the blind?
Again?
Just the front one.
Yeah, just front one is, that's okay.
Yeah, I'm gonna have the bailiff go grab your, are your notepads laying out there, or are they in the folders,
I
or?
think we left them all in there.
They're all laying out on the table.
Okay. Yeah, why don't, y'all want to go back there and go grab your notes? I don't want the bailiff,
Just to grab.
look at whatever your notes may be or anything.
I can grab them if.
Okay, if you want to do that, that'd be fine. Yeah, I'd rather just not have somebody that's outside the jury going and grabbing notes that are not contained in your folders. All right. And I guess real quick, since I forgot to ask this question beforehand, after I'd resolved the jury instruction issues last night, I think it was. I don't know. It's all blended together at this point. And the set that I had emailed to y'all, I think it was last night after we got done, was both sides good with the clean set of instructions that I emailed?
Plaintiff, Your Honor. Thank you.
Okay. Obviously subject to what we had talked about before, but in terms of what I'd ruled, y'all were good with the clean set that I had done in accordance with that. All right.
Subject to objection.
Yeah.
You don't have a pen, I brought an extra one.
All right. Everybody got their own notes back and got pens and ready to go? Okay. All right. I'll give you some instructions now, and we'll go ahead and start proceeding. Members of the jury, I'm now going to tell you about the rules of law that apply to determining whether punitive damages should be assessed, and if so, in what amount. When I finish with these instructions, the parties will present additional evidence. You should consider this additional evidence along with the evidence presented, and you should decide any disputed factual issues by the greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. You are to decide the amount of punitive damages, if any, to be assessed as punishment against the defendant. This amount would be in addition to the compensatory damages you have previously awarded. In making this determination, you should consider the following. A, the nature, extent, and degree of misconduct and the related circumstances, including the following. 1, whether the wrongful conduct was motivated solely by unreasonable financial gain. 2, whether the unreasonably dangerous nature of the conduct, together with the high likelihood of injury resulting from the conduct, was actually known by the defendant. 3, whether at the time of the loss, injury, or damage, the defendant had a specific intent to harm plaintiff, and the conduct of defendant did in fact harm plaintiff. And B, the financial resources of the defendant. However, you may not award an amount that would financially destroy the defendant. You may, in your discretion, decline to assess punitive damages. When determining the amount, if any, of punitive damages to be awarded, you may impose punitive damages to punish the defendant only for the specific conduct that you have concluded caused plaintiff harm. You may not award punitive damages to punish the defendant for anything other than the conduct that injured plaintiff. That is the law that you must follow in deciding the second phase of the case. In a moment, the attorneys will make brief opening statements to you, and then we'll call witnesses. When they are through, I will have a few final instructions about your deliberations. And like before, you're going to get a written set of these instructions to go back to you. All right, so Mr. Friedman, you want to do a brief opening?
Mr. Rush will handle it.
Mr. Rush, okay.
May I proceed? Good morning, still in the morning. On behalf of both Mr. Young and our team, I want to say thank you. I know Zach feels heard in a way that he hasn't felt for over 3 years since the segment was played. And I can't tell you how much that means to both Zach and to our team. You've also decided how we felt that CNN's conduct in this case is deserving of punishment. That a message needed to be sent in some form to media that the conduct, hunting a man down because you don't agree with his ideals, is not okay. It's un-American. The only way we can send a message at this point is through a fine. It's by punishing CNN where it hurts, the bottom line. We're going to do our best to be brief today and to get our case presented very quickly. The law tells us that we cannot punish someone until we know how much they are worth. A $500,000 fine, $500,000 fine, it's nothing to a man like Bill Gates. His investments make him more than $13 million before he sits down for lunch at halfway through the day. To put it in perspective, a $500,000 fine to a man like Bill Gates is the equivalent to a $2 fine to an average person. So, to punish CNN, you need to know how much they are worth. To help you understand how much CNN is worth, we're going to call just two witnesses. You're going to see some tape from CNN CFO, where we asked him some questions about CNN's financials. And you're going to hear from our expert, our financial expert, who's specialized in reading company financials. And he's going to help you understand what CNN's balance sheets show about their net worth. Once we give you the context you need, you're going to be asked to send a message. This is not a slap in the wrist type of situation. What we saw during phase 1 is that CNN thinks it can do what it wants. They argued it's perfectly acceptable to disagree with a man's ideals and spread lies about him around the globe. They ignored Zach's requests not to publish defamatory content. They treated him as guilty until proven innocent. And they labeled him as a criminal for their own benefit. I'm sure when I sit down, Mr. Axelrod is going to get up here and he's going to tell you, we've heard you loud and clear, that they understand. But those statements ring as hollow as their apology to Mr. Young. The company has proven that they will provide apologies to avoid consequences. As Mr. Friedman told you yesterday, you are the arbiters of justice. You will all decide how much CNN needs to pay to feel that to be punished. We are here to give you the information and provide you what you need to make that decision. And that's what we're going to show you. Thank you.
Mr. Axelrod.
Yeah, thank you, Your Honor. So obviously it goes without saying that we're disappointed in the verdict, but that doesn't mean, as I said, that you all didn't do your job. As a trial lawyer, you come in and you hope the jury agrees with you. Sometimes they do, and sometimes they don't. But the first thing I said yesterday, and I still firmly believe, is that you want a jury who's going to go through the evidence and they're going to really put the time in. And obviously you all did that. And we appreciate that, even if things didn't work out the way we wanted it to. So you've obviously found that CNN committed defamation in this case. So I'm not going to tell you that everything's roses and butterflies, because it's not. You found differently, and I'm not going to bang my head into a brick wall. And your judgment is sound. But just because you found that CNN is liable in this case doesn't mean that CNN is unredeemable. And it doesn't mean that CNN should be buried. It doesn't mean that CNN isn't important. And let me just give you a few examples of that. You heard General Young, plaintiff's expert, testify, and he kind of made this offhand comment. I thought it was very interesting. He said he was watching the coverage of the wildfires in Los Angeles, which are really heartbreaking. And he said that CNN's coverage was outstanding. And he wasn't wrong. Because when natural disasters break out, CNN is there. And that's hurricanes, that's wildfires, that's earthquakes. When conflicts erupt, like some of the ones we've heard in this case, CNN's there. And providing all of that content, that really important content's expensive. But it has a really tremendous value. Because we as Americans need to understand what our fellow Americans are going through, if they're in California, or if they're on the Gulf Coast and get hit by a hurricane, or if there's an earthquake in Northern California, or if there's a war in Ukraine. All those things are really valuable. So you've made a decision that CNN's liable, but that doesn't mean that there isn't, a reasonable path forward. So over the next few hours, I hope it doesn't take that long, you're going to hear about CNN's net worth. And you're going to see that the net worth of the company is actually in a subtle decline. You're also going to hear about the headwinds facing the entire media environment. Media is changing really quickly. You're going to hear some of the details about that. CNN still is a valuable asset because of what it does, because of that important information that it delivers. But there are really big challenges that it faces. And you're going to hear that for that reason, almost any amount of punitive damages, and even your verdict right now, will serve as a real punishment. And I'm not coming here to tell you that what you all have done should be the end. You've decided that punitive damages are warranted, so I'm not going to tell you that some number isn't warranted. But I am going to tell you that your judgment has an effect. What you've already decided has an effect. Sir, do you have some water? Do you need any?
Yeah, I like some water.
You okay?
Yeah,
Your Honor, may I approach?
You may.
thank you.
You're welcome. I'm not going to tell you that, I am going to tell you that your verdict already has an impact. When a media company like CNN that says that we value trust, our trust with the world, when you have a verdict like this, it delivers a message. And you've done that with your verdict. But, that doesn't mean that CNN should be completely disregarded. So what's really important is one of the instructions that the court read to you about punishing CNN solely for the conduct that occurred in this case. And it's really important because you're not going to hear about any other defamation cases that you're punishing CNN for. That's not going to come into evidence. You're not going to hear that. Your job is really focused on this case. And so this phase is really focused on punishing CNN for the conduct in this case. The conduct of CNN in any other case is irrelevant, and the conduct of any other media company is irrelevant. So at the end of this time, in a very quick, short order, I'm going to come back and talk to you about what we feel is the appropriate amount of punishment CNN should suffer, in addition to what you all have already found. So thank you, and thank you again for, obviously, you put in 7 hours and then 2.5 days. You all went through the evidence, and we all really appreciate it, even though we're a little bit disappointed, but that's the way the justice system works, and all we can be guaranteed is a fair trial. So thank you.
Raymond, your first witness.
Please call Robert Johnson.
And while you're getting Mr. Johnson on the depot designations for Mr. Cohn, do y'all have those that you can send to me?
Yes, we'll put them in.
Or a printout or email them to my assistant?
Can we email them to me?
Yeah,
We received those at 8 o'clock.
I understand. I hadn't seen them either, so. Do you have them printed out, Mr. Bailey? What you got? Or you got an email? Okay. All right. I'll have them emailed to my assistant. Mr. Johnson? Hey, come around on up to the.
Thank you, Your Honor.
And if you could, raise your right hand, face the clerk.
Do you solemnly swear or affirm that the testimony you shall give on this issue shall be the truth, the whole truth, nothing but the truth, so help you God?
I do that.
Just have a seat there and position the microphone where it's facing close to your mouth so that we can pick you up.
Sure, Your Honor. Thank you.
Do you have notes on which ones you're objecting to?
Yeah, we're reviewing that, Your Honor.
Oh, okay. All right. I was going to try to multitask. Yeah, you move the podium around, that's fine.
Pretty soon, we don't know obviously, pretty soon this will be about 45 minutes or so. So we could do it now, or we could and stop in the middle, or we could go to lunch now if the food's here and then do it after, whatever's what
Yeah.
we need.
We don't have food here, do we? Yeah, I think somebody take care of ordering that? I was hoping.
We've got food on the way.
Okay, it's on the way. All right, yeah, so let's go and we'll see when the food gets here, and maybe it's a good breaking point, moving from direct across. So, Mr. Delich.
Thank you, Your Honor. Can you go ahead and introduce yourself to the jury?
Sure. My name is Robert W. Johnson.
And what do you do for a living, Mr. Johnson?
I am a forensic economist.
And what's your academic background?
I have a bachelor's degree in business administration with a major in economics from the Baruch College of the City University of New York. I have a master's degree in business administration with a major in finance and investments from Stanford University Graduate School of Business, as well as postgraduate training with the Strategic Planning Institute and the American Management Association.
And so you said you're a forensic economist. Can you tell me a little bit more about your professional background?
Sure. Out of graduate school, I went to work on Wall Street as an investment banker for the firm of Donaldson, Lufkin, and Jenrette. Our clients were the top 100 financial institutions: Bank of America, Wells Fargo, all 50 states retirement systems, and I also worked in mergers and acquisitions while I was there. From there, I went over to American Express Investment Management Company, not the travel part. We did managing people's retirement income. We managed $700 to $800 million of people's retirement income, and I managed most of the bond portfolio section, which was about $200 to $300 million. From there, I went to work for a company called HRB Singer. Our clients were primarily defense contractors. On our part, I ran mergers and acquisitions in that area. We did signal intelligence for various agencies of the Department of Defense. From that company, I transitioned over to a division of FMC Corporation, their defense equipment division. It's a $3 billion company, division that it was. I ran specifically what's called capital budgeting. What that simply means is that any time we purchased a piece of equipment that cost more than $1 million, I had to do all of the paperwork to ensure that we got fully reimbursed as a government contractor. Since 1981, I've been taking my academic training and my real-world experience and putting them together in the field of forensic economics.
And have you ever written any articles or books?
Yeah, I've had articles published in the American Bar Journal, the American Journal for Trial Advocacy. I've co-authored a book for Lawyers Co-op. I've been quoted in the Wall Street Journal, Barron's, Washington Examiner, Washington Post, and CBS Good Morning America.
And so you're here as an economic expert, correct?
That is correct.
Have you ever been qualified as an economic expert before?
Oh, sure. In my home state of California, we have 58 counties. I've qualified in all 58. There are 4 federal districts in California. I've qualified in all 4.
So that's California. You ever qualified in any other states?
Oh, sure. Let's see. We've got, this is not my first trial where I've qualified here in the state of Florida. I've also qualified in Alaska, Hawaii, Washington, Oregon, Idaho, Montana, North Dakota, South Dakota, Arizona, New Mexico, Texas, Massachusetts, New Jersey, New York. I've got 45 pins in the map right now. There are 45 states plus 2 territories. And I hope to get all 50 before I finally retire.
Well, I wish you luck on that. Do you always work for the plaintiff side?
No, I'd say when the cases first come into our shop, better than 50, 60+% of the time, we're being retained on behalf of the plaintiff. As they work their way through the litigation process, cases start to settle, we get to the deposition stage. Now, cases have settled, so now it's up to 75% remaining plaintiffs. As we continue on in trial, like we are here today, almost 95% of my defense cases have settled, so it's 95% plaintiff.
So I bet your company has a website, right?
Yes.
Do you ever put information about the cases you worked on up on your website?
You know, I can only put on my website those cases for which my clients give me permission. If they say don't publish, even though like here is a public trial, they say don't publish, I'm not allowed to publish.
Do any of your defense clients ever let you publish information about their cases?
You know, I've been trying for 40 years to get them to do that. Even when they get the verdict they want, they say, no, Bob, don't publish. I have to respect that and not publish.
Why do you think they do that?
I don't think they want anybody to know that they've been sued.
Makes sense. So you're being paid for your time here, right?
I am retained for my time, yes, sir.
So what's your hourly rate?
$975 an hour, sir.
And what were you asked to do in this case?
Well, my task in this case was to use the standard methods of economic analysis used and relied upon by economists to quantify the financial condition of Cable Network News, Inc. regarding their ability to pay and their relative financial condition currently.
Okay. Corey, can we go to the next slide? All right, so this is what you're talking about. You're here to discuss financial condition and ability to pay.
That is correct, sir, yes.
All right. In the past 5 years, how many times do you think you've testified at a deposition or a trial?
Oh, Jesus. Several hundred, definitely, several hundred.
Like, how many of those involve punitive damages? All of them?
No, probably less than 1%.
Do you work for CNN?
No. I'm not an employee of CNN.
So it would be fair to say you're like an outside the company expert.
That is correct, sir.
Have you ever testified at trial on punitive damages on behalf of a defendant?
No.
Why not?
Well, I think basically the reason is because most corporate defendants have people who they employ. They have a chief financial officer, they have a chief executive officer, they have accountants who they pay significant amounts of money to understand all of the internal finances of the company. It makes no sense, from my perspective, to hire me, an outsider, who won't have all the intimate details of the company when they have somebody who they've already paid to come in and talk about something they already know. You bring your best known people to talk about your finances, and nobody knows the company better than the people inside the company.
So I think I forgot to ask you this. Can you tell me about, just at a high level, some of the cases you've worked on in the past?
Sure. I was the economist for the estate of Kobe Bryant in the unfortunate helicopter crash, Pan Am 103 over Lockerbie, Scotland, the MGM Grand Hotel fire for Lloyd's of London, the BP oil spill up in the Gulf of Alaska. The BP was in Mexico. The Exxon Valdez was up in Alaska. We did 25 pro bono, which no charge cases out of the tragedy at 9/11, both at the Pentagon and at the World Trade Center.
Your Honor, I've been informed that the food is here.
Okay. Want to keep going? Or how long did you think you'd have?
30 minutes, maybe?
You all right?
I say keep going.
All right, yeah, well, let's go ahead and get through direct then.
Okay. All right, so we got this new slide up here. So how does a forensic economist assess a company's financial condition?
Well, typically the way we do it in a case such as this, we look at a company's economic health, economic wealth, and their financial status.
All right, Corey, can we go to the next slide? So let's talk a little bit about what is economic health and how you measure it.
Well, when we look at economic health, we're looking at things like their company's sales, revenue, their net income, their profit, and what we call cash flow or cash flow profit.
Corey, can we go to the next slide? So the first one you said was sales and revenue, right?
Right.
So can you explain to the jury what that is?
Sure. Sales is the amount of money that a company makes through the sale of its goods or services. It's all the revenue they bring in for all the effort they put out to their clients and customers.
And what about net income?
Well, net income, you start with the sales, and then you deduct all the allowable expenses. And if you have anything left over, that's called your net profit or your net revenue. That's your net income or net profit.
And what about cash flow?
Okay. Cash flow, and this is a unique term, it's cash flow profit from operation. Remember I said you start with your revenue, and then you deduct all the expenses. But there are expenses that you are allowed to deduct for tax purposes that you never write a check for. Items such as depreciation, amortization. So what you do is you get that revenue minus expenses, but now you add back all that money you never wrote a check to. So this is your real cash flow or cash profit. That's probably the most significant item in terms of looking at a company is what is their cash profit.
All right. And so you also mentioned you look at economic wealth. So what are the measures of economic wealth?
Well, we look at what's called net worth. We look at cash on hand. We look at dividends. We look at capital expenditures. And we look at an economic metric called free cash.
So before we go, what's the difference between economic health and economic wealth?
Well, anybody can be health. In other words, how much revenue you have, how much profit. But when you want to look at another way of looking at a company, you want to look at how wealthy they are. You know, how much are they able to sustain in wealth?
All right, so let's talk about net worth first. Can you explain to the jury what net worth is?
Sure. The simple accounting definition of net worth is you take all your assets, the value of all your assets, and you deduct from that all of your liabilities, all that you owe. If your assets have a greater value than your liabilities, you have a positive net worth. If your assets are less than your liability, you have a negative net worth, which would mean you're probably getting close to being in serious financial straits. But it's just assets minus liabilities. That's all it means.
And what about cash on hand?
Well, cash on hand and cash equivalents. Everybody knows what cash is. It's basically piles of dollar bills. Cash equivalents is, let's say you take your cash and you convert it into a certificate of deposit. That's good for 30, 60, 90 days. Well, it's not cash, but if it can be converted from that certificate of deposit into cash within 90 days, that's what we call a cash equivalent. That gives us an idea of how much cash the company has access to, even though they may not have it in straight dollar bills. They've got access to it within 90 days.
And then I think the next thing you mentioned was dividends, right?
Dividends, right. Dividends are money where they distribute earnings out of the company. In other words, they're taking cash and they're sending it out to whoever the shareholders would be. That could be an individual, that could be a parent company that may own them, but it's cash that's leaving the company that they've already decided their CEO, CFO, their accountants have blessed can leave and do no harm.
And then I think the next measure we were talking about was capital expenditures. What's a capital expenditure?
A capital expenditure are those items that a company purchases that are big, long-lived assets. We're talking about land. We're talking about buildings. We're talking about plant and equipment. These are the key things that you need to keep and maintain so that you will have an ongoing core of business. It could be a studio, whatever, but these are major expenditures.
All right, I think our last vocab word was free cash. What's that?
Okay, free cash is an accounting term. So what we do is we start with cash flow from operations. Remember, this is revenue minus all the expenses that you actually write a check to. So this is your pile of cash after you've paid off everything, all your expenses. Now, we're going to deduct from that pile what we're going to use to purchase our capital expenditures, those core, long-lived assets that keep our company going. So if we have anything left, that's called free cash. That cash, you're free to do whatever you want. You can go buy another company. You can go build a studio. You can do whatever you want. You've already paid off all your expenses. That's what's called free cash.
So why are we talking about all these different things? Why not just use, say, net worth or profit when we're trying to talk about the financial condition of a company?
You know, that's because there's no one metric. There's no one measurement that can completely describe the company. One is not complete enough.
So you gave us this picture to help explain this to the jury. Why is there an elephant on the screen right now?
Well, it's an illustration of why I need all these different metrics. Try to get as many as I can to describe what we're talking about. In this picture, you see 5 people, each touching a different part of the elephant. Somebody's got the nose, somebody's got an ear, somebody's got a foot, somebody's got the body, somebody's got the tail. Each one of them can accurately describe the part they're touching. But no one of them can describe the whole animal. You try to get as many different measurements so you're able to describe the whole animal, which is why we can't use just one.
And you looked at CNN's financial condition for this case, right?
That is correct.
So what did you look at to try and do that?
Well, we would like to look at all of their financial numbers. We'd like to see their balance sheets, their income statements prepared by their accountants according to generally accepted accounting principles. That's the sort of the standard that we'd like to have. Unfortunately, in this case, we were never provided with those financial documents, in a sense. But we did get, what they did provide us with was their, what's called the 1120 U.S. corporate income tax statements. So these are their company income tax statements for the years 2021, 22, and 23. They have not issued anything to us or provided us the documents for 2024 or any interim documents for 2024 for CNN Inc. on our part. That's what we would like to have, but we don't have it, so we're going to rely on the information that we have. We do know when we look at tax documents, and I compared them to the regular corporate documents we'd find in a company, we know that the documents that are prepared in traditional financial statements for use to give to your shareholders or to go to the bank, usually to get a loan, those are done according to generally accepted accounting principles, and that's one set of rules. When you prepare a tax statement, that's not done according to generally accepted accounting principles. That's done according to the IRS rules on that part. So it's okay for a company to have 2 sets of books. One you show to the shareholders and one you show to the IRS. Perfectly, there's nothing wrong with that. But when we look at those documents, the ones that are the taxes, they're designed by the company with good accountants to minimize taxes. They're much more conservative than the ones that you go and show to your shareholders on that part. Both can be accurate, but both will be different because you've got a different set of rules in that sense. So we did look at those tax documents, their returns, that were signed by, the last one was signed by Ernst & Young, one of their CPA firms that they have working for them. So we believe them to be accurate, valid, and truthful.
You said signed by Ernst & Young. What's Ernst & Young?
Ernst & Young is one of the big, I think there's only now 4, major accounting firms in the United States of America. They are one of the big 4, so to speak.
And so besides the tax documents, do you review anything else as part of your evaluation?
Well, I did read a deposition of Mr. Adam Cohen, and I did read the deposition and report of the defense economist, Dr. I'm apologizing now because I know I'm going to mispronounce her name.
Can I help you? It's
Yes.
The report of Dr. Junasia?
Dr. Junasia, thank you.
Understood. All right. So, can we go to the next slide, Corey? And one more. All right. So let's talk more specifically about cable news networks' economic health. What am I looking at right here?
Well, based on their tax documents that we reviewed, we're looking at their revenue. And we can see that in 2021, it was $2.2 billion. 2022, it was $2 billion. And 2023 is $1.8 billion. That $1.8 billion averages out to $4.9 million per day. An average, that's every day, 365 days a year. On average, that's how much money is flowing in to CNN.
So like Monday, $4.9 million comes in.
Tuesday, another 4.9. Now, some days it'll be higher, some days it'll be lower, but that's the average revenue per day.
And go to the next slide, Corey. All right, and what did you find about CNN's net income?
Well, CNN's net income, again, these comes from the same tax documents. That's 2021, it was $0.6 billion or $600 million. 2022 was $0.3 billion or $300 million. And in 2023, it's $0.4 billion or $400 million.
And go to the next slide, Corey. What about net worth? What did you find about CNN's net worth?
Well, CNN's net worth transitioned from $4.4 billion in 2021 to $2.2 billion in 2022, and it increased back up to $2.3 billion in 2023.
All right, so CNN's net worth is about $2 billion?
Oh, no, CNN's net worth is $2.3 billion.
$2.3 billion, sorry. What's 10% of $2 billion?
About $200 million.
$200 million. Can we go to the next slide, Corey? All right, and this, can you remind me, what was cash flow profit again?
Again, cash flow profit this is the amount of profit you had after paying off all your expenses, but it's the amount from operations for which you actually wrote a check. It is the pile of cash profit they said they had, according to their tax return, in 2023.
So, have you ever heard somebody say, corporations are people too?
Yes.
Okay. So, I know it could be a kind of controversial subject, but I want you to assume that you should treat a company like a person. Can you do that?
Okay.
So, with that in mind, which of these measurements we talked about do you think you recommend using as most important for purposes of punishment?
That would be revenue.
Why?
Well, let me tell you a story. My son, when he was 16 years old, was captain of the football team, honor roll student. But every now and then, he would do something that would remind me, Dad, I'm 16. My brain's not fully formed. I don't always make good decisions. He got a call one day.
You got another bottle of water. Thanks, sir.
I'm sorry.
All right, go ahead. Continue.
He got a call one day from a young lady who asked him to come over and help him study for a test. I said, son, you've got that same test the next day. And I said, I'm going back to the office. You stay here and study. Backed my car out of the garage, went to the office. I'm sure not 5 minutes after I turned around the corner, he backed the other car out of the garage. In his haste, he took off the side mirror, but he didn't even know it. I come back, open the garage. There's no cars in there, but there is the side mirror on the floor. So, okay, I know what happened. I sit down. 20 minutes later, he pulls into the garage, opens the door, comes in. He's got the side mirror in his hand, and he's going, yeah, Dad, I know. I already checked. It's going to cost $200. I'm going to go in my room. I'm going to get $200, and I'm going to hand it to you. We're good, right? I said, no. That's where it starts. He said, what? What do you mean? I said, no. We told you, no, you weren't supposed to go. You're supposed to stay and study. But I studied. No, you broke the rule. He said, son, you are not grounded for 2 weeks. Now, my son is really quick on his feet. He said, Dad, I'm grounded? Yeah, and that means no allowance either. He said, Dad, I got expenses. I got pizza after the game. I might go to Blockbuster and get a video that tells you how old it was. I only save 50 cents a week. I'm going to go get another buck and put it in there with the 200. You're still good? No. You lose all the money. I said, son, you got to understand. If you're a player at the professional level and you miss the plane to the game because you were out partying hard the night before, if you think you sit down on Monday morning with the coach and you say, I'm sorry, and the coach says to you, you know that $1 million game check you were supposed to get? It ain't coming. And you go, wait a minute, coach, the Ferrari's coming Tuesday. No. If you were a plumber and you blow the job because you didn't read the plans, they don't dock you what you save. They dock you your whole paycheck. And if you're supposed to treat a company like a person, you start with revenue.
Right. So in your example, the allowance is the revenue.
Correct. That's his revenue. Just like a company, they get revenue.
And so we're talking about some big numbers there, like net worth was over $2 billion, I think, and revenues were similar, right? Over $2 billion?
That is correct, sir.
$2 billion. How big is $1 billion?
Let's see. If you take $1 billion and you put it in the bank, year one of day one, and the next day, on day two, you take out $1,000. On day three, you take out $1,000. And you keep taking out $1,000 every single day. This is the year 2025. You would still have over $260 million left in that bank account. And that's assuming you didn't get 0% biblical interest. And I'm going to tell you they had interest in biblical times. That's how big $1 billion is.
Wow. No further questions, Karen.
Y'all want to go take a break and eat? Yes, we do. All right. Go ahead and put your notepads in your folders, and we'll leave them on your chairs there. Y'all still have stuff back in the deliberation room?
Yeah.
All right. All right. What we'll do, I guess we'll use that like our jury lounge for now. So we'll bring the lunch back there. But go ahead and leave your notepads out here for now, because even though y'all already deliberated this phase 2, you're not to have discussions and start doing any sort of deliberations at this point. Are your phones still out here or
Mine's in the lounge, and I would like to use it on the board.
in the lounge? All right, well, why don't we do that? Well, do you need to get anything out of the deliberation room during lunch?
Not purse.
You need to grab your purse. All right, well, I'll let you grab your purse before we go back out to the lounge, but we'll take the lunch out to the lounge and let you go out to the lounge.
Okay.
Let me go ahead and read the instruction note to you. And on top of that, like I said, don't start discussing phase 2 or having any discussions about that. We're going to take our lunch recess. Remember, all the rules I've given you apply even when we're outside the courtroom, such as at lunch. Remember the basic rule: do not talk to anyone, including your fellow jurors, friends, family, or coworkers, about anything having to do with this trial, except to speak to court staff. This means no emailing, text messaging, tweeting, blogging, or other form of communication. You cannot do any research about the case or look up any information about the case. That includes, if you're getting on your phone to make a phone call, do not talk about anything that already have transpired in this case at all either. Remember to observe during our recess the other rules I gave you. If you become aware of any violation of these rules at all, notify court personnel of the violation. If you do use your phones, also do not use it to access any media, internet, social media platforms, or anything of that nature as well. And I also caution everybody else, attorneys, public, members of the media or whatever, since they're going to go out there to go to the lounge and use the lounge and maybe using the phone, keep away from the jurors during that time. Do not interact with, look at, talk to, overhear conversations or anything of that nature. All right. If you want to go back and grab your purse real quick, I'll let you do that, and then we'll get everybody out together. We got an extra bailiff to have up here outside the lounge. Yeah, I mean, if you need to walk down the hall and go to the restroom or whatever, that's fine, but stay close by. And what we'll do, we'll take a half hour till 1:45 and get you back. Okay? All right. With that, jury will be in recess till 1:45. All right, y'all be seated. Jurors are out of the courtroom. I need to go back and finish reviewing the rest of Dr. Janesia's depo. The next thing that's going to happen is we're going to have video of Mr. Cohn. We need to do something on resolving these depo designations. Where are you guys on looking at those?
We want to raise an issue with regard to that.
What's that?
We want to raise an issue with regard to that, Your Honor.
Yeah, what's that?
Right.
Yeah, go ahead.
As you know, Your Honor, we received the motion eliminate to exclude our sole witness in phase 2 at 5:45 this morning. We then received the deposition designations regarding Mr. Cohn at 8 this morning. I was literally in the parking lot outside preparing for the motion eliminate argument. Mr. Cohn's deposition was taken, I believe, November 20th, 21st. I'm not entirely sure. They've obviously reviewed it very carefully because they filed a motion, right, Your Honor, regarding WBD that was primarily based on Mr. Cohn's deposition. There is simply no excuse that we are seeing this for the first time at 8 in the morning to radically reshape phase 2 of the case by both eliminating our sole witness and adding a number of designations. I don't know if you've been through them yet, but a number of depositions. I've skimmed it. I haven't reviewed in any detail. This is highly prejudicial to have this at the last second. You know, Mr. Delich said there's no excuse for filing the motion eliminate this morning. He's just busy. I appreciate that. We're all busy, but the prejudice is vast. This is the phase 2 case we planned. We have planned it. They had Ms. Gennaro's report since December 23rd. They deposed her on January 2nd. With regard to Mr. Cohn, again, deposition was taken well over a month ago. They've reviewed it very carefully. There's no reason why we got this at 8. So we would renew our opposition to the motion eliminate regarding Dr. Gennaro on the grounds that it's prejudicial, and we'd ask that none of Mr. Cohn's testimony come in. It's simply too late to burden us with having to review them make objections, which we have plenty, make counter designations, which we have plenty. It's simply at this stage, they made a choice to wait. Sometimes choices work out, sometimes they don't, and we would ask that all Mr. Cohn's testimony be excluded on that.
Right. Why are we getting yeah, I mean, I've spent a considerable amount of time going through and reviewing all the other depot designations prior to trial. Why are we, and some of them pertain to phase 2 type of issues, but why are we getting, I don't know how long it is because it's in all, what I'm reviewing on my computer is all in one spreadsheet. But I don't know how long I mean, it's considerable in terms of the designations here.
Sure. I think in total it's about 20 minutes of testimony for Mr. Cohn. In terms of why, when we submitted the original designations, we had agreed with the defendant that we would put phase 2 off for later, and then as happens in trial, we never agreed on when later meant. Obviously, we've been for trial, so when we had a second break, we sent over the designations. It's really not that much. If they don't want to have video, we can have it read in. It's not an insane amount of testimony. There was no court order requiring phase 2 yet to come in. The parties understood phase 2 would be pushed for later. And also, Your Honor, in terms of the motion in limine on for Dr. Janeza, as you will recall, defendants wanted to start financial discovery much earlier in this case, but defendants wouldn't allow it, and they held it until...
Whoa. There was an appeal that was pending, and if I correct, they didn't file a motion because y'all agreed to go ahead and hold off on it. So there was an agreement. So let's not... You want $1,000? You want $1,000?
No, Your Honor, of course.
All right. Then let's accurately misrepresent. They wanted to push it off, which they have a right. They could have asked for a stay of that discovery. You agreed to it, so let's not cast aspersions.
Your Honor, I'm not casting aspersions. If the court will recall, we reached an agreement, and there was there was no stipulation filed, and the parties disagreed on the scope of that agreement.
Well, we had issues later on where y'all were fighting about that, when the triggering date to start it was, but y'all had agreed to hold off for a while.
Your Honor, I never said we didn't, but there came a point in time after the first DCA rule when we wanted to move forward, and under the language of our emails and communications, we read it. And, again, I don't remember if the court ended up resolving it because it ended up resolving on its own, but we read it as our agreement going until the first DCA rendered its decision. The defendant came back and said, no, it stays until the disposition of the motion for rehearing en banc.
And I know, I resolved it.
I understand you resolved it, Your Honor, but
your point being, okay, you wanted to delay it.
I wasn't misrepresenting anything to you, Your Honor. I take that very seriously. I never make any misrepresentations to the court, so I'm not casting aspersions. When I said that...
What's the point of they wanted to delay it? What does that matter on a depot that was taken in November? I had a whole bunch of depot designations that I resolved before trial. We didn't have an order that separated out depot designations for phase 1 versus phase 2, but why... I mean, I'm dealing with a motion, and I understand the depot of Dr. Janeza was taken Thursday before we started trial, and I said that earlier to Mr. Delich. I understand this was taken late, but now we're on day 10 at 5:51 this morning. There was a motion filed. I don't know. They're saying at 8 o'clock this morning they got this list.
So, Your Honor, I was talking about the motion in limine, and that's why that's where I was going, which is we wanted to start financial discovery much earlier. We couldn't. Your Honor flagged that this was going to be an issue, that Dalberts were going to be an issue. You yourself, the court, flagged that this would be a problem. And we got it done as soon as we possibly could, given how late in the game Dr. Janeza's deposition taken. So that's what I was talking about with regards to the delay. In terms of deposition designations, both parties had agreed to only submit deposition designations for phase 1, so we just never submitted for phase 2. Your Honor, again, the defendant claims that they'd be highly prejudiced by receiving deposition designations this morning at 8. We'd be significantly more prejudiced after agreeing with the defendant to push it off by not being able to put in any evidence from Mr. Cohn in phase 2. And again, if they don't want to cut videos, that's fine. If they want to counter-designate, that's fine. But it's not a lot of testimony, and we have lunch break now. We've got the recross of, we've got the cross of Mr. Johnson, we've got the redirect of Mr. Johnson, we've got the direct of their expert, Janeza, we've got the cross of it, and the redirect. There is time for them to look at 20 minutes of deposition designations in that time period. It's not that prejudicial. I agree. It would have been better if we got it to them earlier, but the parties have been operating on this schedule. We're giving each other demonstratives right an opening, minutes before the opening starts. I mean, that's just been the schedule of this trial. We've been expediting things as quickly as we can to get things done within the time frame. So should we have sent them earlier? Would that have been better? Of course, Your Honor. But, you know, I'm hearing from the defendant prejudice of receiving them this morning. I mean, the prejudice to the plaintiff to not allowing us to put in any evidence when the parties agreed to put it in later would be astronomically greater.
I mean, as I was scrolling through here, you argue about substantial prejudice to you, other than him saying, I don't know what our net worth is, and we don't have financials like a profit and loss statement or what have you. What evidence as to their cash flow, their net worth, their ability to pay a punitive damage judgment haven't you gotten in through Mr. Johnson?
Well, Your Honor, first of all, the first thing you talked about is very important because the case law in regards to punitive damages talks about when a defendant is unable or does not put forward evidence of its own net worth, it limits the arguments available for a defendant on appeal to try to reduce a punitive damages award. So that in itself is important to us. And then, yes, we're able to get some of the information through Mr. Johnson, that's true, but there's nothing like, you know, hearing it from CNN's own people. That is part of putting forward a case, is not only having an expert do it, but having CNN's own people do it. And so, you know, taking away our ability to say, hey, you heard from CNN directly, or even the jury hearing from CNN directly what their profits and losses are. They're about to get up here and attack Mr. Johnson, as is their right. And we should be able to say, hey, it wasn't just our paid expert, it wasn't just our paid gun. You heard it directly from CNN's own people that talked about some of these numbers.
CNN's own hired expert's going to get up here and say Mr. Johnson's numbers that he used are correct numbers off the tax returns and everything else.
You know, I don't know what she's going to say until she testifies to it. Maybe she will, maybe she won't. But even if she does, Your Honor, it's still not the same. It's a battle of experts. It's not the same as having the CFOs tell the jury directly what those numbers are. And if it's, Your Honor, if it's that simple, if it's just these numbers, what's the prejudice? I mean, this is a defendant that is, you know, saying, it's highly prejudicial for us to go through 20 minutes of deposition designations. I mean, we've been doing that the whole trial. The parties have been adjusting the deposition designations the night before in order to try to get this trial expedited. You ruled on them, but then we removed more, right? And the parties were exchanging depositions and redesignations. You know, I understand the argument is prejudice, but that's not what this is about. This is an attempt to try to keep these deposition designations out because we weren't able to get them over to them earlier. And there just isn't prejudice to them. They have hours between now and when that 20-minute video will be played. And they've had it since 8 in the morning. We sat here doing nothing, waiting for the jury to deliberate from 8 in the morning until almost 12:30, Your Honor. Those are hours and hours of time. They could have reviewed these deposition designations, and they have hours more. And it's 20 minutes. So, Your Honor, I take the concern, but it's not, I mean, that's trial. You know, we turn things around fast in trial.
A few responses. One, Mr. Friedman alluded to an agreement about Phase 1 versus Phase 2 designations. I am not aware of any such agreement. I think my understanding of the sequence is late in the evening of Christmas Eve, we received for the first time deposition designations for Mr. Cohn and Mr. Tapper. On December 26th, after our Christmas holiday, we came back and emailed and said, hey, can we put off, because I think there was a hearing very shortly thereafter where we were going to review the deposition designations. We said, hey, can we put off Tapper and Cohen because they're Phase 2? We just can't get to them right now. We got these in the evening of Christmas Eve. And they replied, these are just Phase 1 designations for these witnesses. And that is as I understand, and my colleagues can correct me, that is the whole exchange with regard to sequencing Phase 1 versus Phase 2. It's been a while since I went into law school, but I took law school classes, but that doesn't sound like offer and acceptance of an agreement to me. There was no such agreement. The second point, Mr. Friedman kept on saying, well, what's the prejudice? It's 20 minutes. You, Your Honor, look at over the designations. They're on collateral issues. Mr. Friedman said, well, we want, you know, the testimony from Mr. Johnson to come in from the horse's mouth. The designations they've put are on collateral issues about, do you have a balance sheet? How do you manage your, how do you track your cash flow? Simply to create sort of a narrative about CNN that's collateral to the issues Mr. Johnson testified to. As I mentioned, highly prejudicial to force us to do this on the fly. And I want to put in the context of the combined attack. 5:50 in the morning, your sole witness is gone. 8 a.m., here are the deposition designations for our witness. People cannot operate in that way. That's not how a trial is supposed to proceed.
All right, well, if Dr. Janeja can testify,
the other thing...
What's the prejudice of allowing this in?
I'm sorry, say it again?
I said if Dr. Janeja can testify, what's the prejudice of allowing them to use Mr. Cohn's depot?
We don't have time to review them, but if Your Honor is willing to take the time to go through line by line and make rulings, I guess that's how it has to go, but we have objections. The other thing is, we potentially could have tried to bring Mr. Cohen here live. Our understanding as of last night was, or our understanding as of recently was, or we just didn't know what was going to happen with the deposition designations. Obviously, Mr. Cohen is in Atlanta now and couldn't travel in time, but we need to get these. There's prejudice. But at minimum, we need to spend court time going over the designations.
Right.
And I need to be prepared to do so.
Some of the other videos that we played, obviously the folks weren't here testifying live except for Mr. Levine. But that's a different issue where you can use his depot prior to trial as substantive evidence during your case, which he did. To the extent that Mr. Cohn's not the corporate representative, what's the grounds of using his deposition substantively in your case in chief?
He is the corporate representative.
Was he designated as the corporate rep for punitives?
On financial topics.
Oh, was he? Okay. All right.
Also, Your Honor, the parties exchanged and had court.
All right. So the issue on Mr. Cohn not being here live, if he's designated as the corporate rep for financial issues, then...
It's not an admissibility issue. It's a prejudice issue.
Okay. All right. Where are y'all on reviewing those designations? Or are you guys sitting on your hands saying we hadn't had a chance to review them, but we hadn't really even started cracking down and seeing if we have an objection to these things?
I've made it through the first third, Your Honor, but we're also scrambling to prepare crosses and directs in the context of the motion eliminating, the context of just saying demonstratives, literally, as Mr. Johnson was taking his seat. So it's been a lot to do, Your Honor. I have not been sitting on my hands.
Your Honor, can I add one thing? Because the court pointed out something that I overlooked. As the corporate representative, it's our right to play the entire deposition if we wanted. Obviously, they could raise objections to it, but in the middle of our case in chief, they played deposition testimony of Mr. Young without any designations, and the parties did not designate from the other party's deposition, but reserved the rights to use them. So the idea that there is some super surprise shock prejudice that we are now providing them with a limited form of that deposition, I think should be viewed in context.
I think the Mr. Young deposition designation was impeachment evidence.
It was not. It was not impeachment evidence.
Well, regardless, I mean, the whole point of doing depot designations before trial is so that, especially if we're using video, y'all can, if there are objectionable questions beyond just form, or even if there are form objections, we can resolve them, and then we're not playing this out in front of the jury. You can cut your tape on your video. You can do all those sorts of good things. All right. Y'all need to finish reviewing what objections you do have on certain of these, because obviously if they're objectionable questions, you can't use the whole deposition, regardless of whether it's corporate rep or not. So I'm going to have to some extent, potentially resolve any of these objections. And whether it's somebody reading them or you're doing a video, and either way, I'm going to have to resolve the objections before the question's asked and any sort of answers being given. So why don't you do that? I need to finish reviewing Dr. Janesha's depot. And they're going to be back in 15 minutes. So why don't you spend 15 minutes doing that? I flipped through a bunch of these, and I'm only looking at the question and answer, but I can tell based on the way it's cut that there is an objection that was raised somewhere in there. Some of these things, I don't know that there's, what's your position at seeing that? I don't know if there's really an objection to that. So, I think there's a number of those things that probably wouldn't have any objection, but on some of these other ones, I could tell there's an objection there, and I don't know what the objection is because I'm just looking at what was cut and pasted into this Excel spreadsheet. So why don't y'all spend the next 15 minutes doing that? Let me finish up with y'all's expert stuff.
Yes, Your Honor, just in terms of timing, I really need to go outside and make a call to my client. And I know we're supposed to be back in 15 minutes. Is there any way we could just have a couple more minutes? It takes time to run outside and find a place to talk.
All right. What do you want? 20 from now? Or till 5 till, something like that?
5 till would be great.
All right. All right. I'll be back here then.
Thank you, Your Honor.
And I didn't want to say this earlier, but when they had come back with oh wait, that one says we have reached a verdict. Okay, never mind. I thought there was another note I had, but
Your Honor, you do have a note you placed under seal.
yeah.
Is it still under seal?
It's going to be under seal till the end of the trial.
Okay.
All right.
Thank you.
Nasia talked about of what Mr. Johnson didn't take into account had to do with these allocation of expenses from Warner Brothers. I think he came from, not from CNN I don't know if it was CNN Worldwide numbers or whatever, but she was saying he didn't take into account an allocation of expenses. And looking at the questions you were asking is, well, how can he take into account things that he weren't provided, sort of thing, or something along those lines? Was the information that she was saying he didn't take into account, was it documentation that was produced during the course of discovery?
So yes, Your Honor, I don't want there to be a confusion about that.
Okay.
It was produced. It's just it's for CNN Worldwide, which is the reporting entity and not the defendant in the case. So CNN's position has been that we should look at it as the CNN business is structured. So they look at it as CNN Inc. plus whatever constitutes CNN Worldwide. And so she's we think it's inappropriate because it's trying to take an expense allocated to this reporting entity that's not the defendant in the case and saying we should have incorporated it, he should have incorporated his analysis of CNN.
All right. I don't think I was 100% clear when we were arguing about it as to whether the information was provided, because based on the questions, I was like, well, wait a minute, maybe that was not what we talked about when we were arguing this earlier. But what you said, I think, was what I remembered from before, but I was looking at something different, or how I read the transcript anyway, and the questions you were asking, I wasn't 100% clear.
Yes, Your Honor. I think I don't want to speak for him, but I believe Mr. Johnson was just trying to convey that we for CNN Inc., the specific entity, we didn't have kind of traditional statements, and we did get some of those, like profit and loss statements for CNN Worldwide, but we never got anything like that specific to CNN Inc.
Okay. All right.
Your Honor, both experts are on a level playing field. I don't think Mr. Young said anything different, but they're on a level playing field as far as what documents were provided and what they think.
Okay. Yeah, and that would have been my concern, was that she was looking at something, there was some questions earlier, did you talk to the CFO or, do any of that stuff? And she was saying no. But then when you were asking the questions, I thought everybody was on the level playing field, but then the questions seemed to suggest something else. So I just wanted to be clear on that. Okay. You doing cross?
Yeah,
You're doing cross, Mr. Axelrod? All right.
Something like that.
Something. All right. Let me do this. I'm just going to wait on. Have you had a chance to review the designations at this point, or Mr. Safer, you were reviewing those?
I've been looking through them. I mean, I have opinions about the designations, but I don't have anything systematic to you that can say, no objection, these are counter designations. I just, given how crazy today has been, all the things we do, I don't see any other way we can do it than just go through them.
All right. All right. Well, Mr. Axelrod's doing cross, and then we'll still have redirect with regard to Mr. Johnson. Once you see about who's doing direct on Dr. Janasia, presuming you are, Mr. Tobin? Okay. Mr. Safer, why don't you spend time looking at Mr. Cohen's stuff? Just in the interest of time, and one of the issues I wanted to talk with Mr. Friedman, who's now walked out of the courtroom. I'm hoping that by 4 o'clock we can have done with testimony, and then with him, if the jury's deliberating, I wanted to ask the question of,
And so we've spoken about that in advance, Your Honor, and the answer is yes. As long as the arguments are done and the jury's deliberating, he has no objection to the jury continuing to deliberate.
all right. And I maybe suggest to y'all of considering how much of Mr. Cohen's testimony you want, so that we can be done and arguments can be done by 4:30.
Yes, Your Honor. You're asking whether we can look at cutting some of the designations? Yes, Your Honor. We will take a look and make an effort to do that.
Yeah, I understand why you may want to use some of it, and assuming that I'm going to allow you to use it, but some of it may be not necessarily other than wanting to emphasize the point of what Mr. Johnson testified to. So, all right. Well,
understood, Your Honor. I'll take a look with an eye.
Okay. All right. Then anything else before we get the jurors back?
Let me find Mr. Sanborn really quickly. I don't know where he got off to. Is that all right, Your Honor?
You all have a seat. I'll give you a second to get your notepads and stuff back out.
I grab the water from the man, because there's no waters in there.
There you go.
Thank you.
We got jury box service here.
Thank you very much.
Do I get a tip right now like that?
Thank you. Enjoy your- Thank you.
Thanks.
Everybody all right?
Heavy service here. Thank you.
All right, Mr. Axelrod, if you want to start across whenever
Yes.
you're ready.
Yes, thank you, Your Honor. Good afternoon, It is afternoon. Good afternoon, Mr. Johnson.
Good afternoon, sir.
My name is Dave Axelrod. You and I have never met, correct?
That is correct, sir.
Please let me know if you don't understand any of my questions or if I mumble, which I am apt to do, okay?
Not a problem.
Great, thank you. So, sir, I think one of the things you testified on direct was that CNN generates revenue of $4.9 million a day. Did I have that correct?
Correct. It's the average revenue per day in 2023.
In 2023. And you would agree that that revenue is being generated by all of CNN's businesses, correct? All of its business.
Collectively.
Collectively, right? So that's based on all of the news shows, all of the ad rates, all of the distribution contracts that could have, like, all of the stuff, right?
Everything they charge people for.
Right. And so that isn't just tied to one article or one show like that, right? It's everything, right?
That is correct.
Okay. And so revenue, when we're talking about revenue, that $4.9 million, that doesn't include, you're not including in that number the expenses that are being paid each day, right?
No, as I said before, revenue is what you bring in, and then you have expenses that are assigned to that, and then if you have anything left over, you have a profit.
Right. So out of that $4.9 million a day, there's paying stuff like rent, right?
Correct.
Employee salaries,
Correct.
productions in California for wildfires, things like that.
Whatever they're paying it for, sir.
Right. All of those kinds of expenses, right?
All of those expenses, and
Right.
yeah.
Okay. So I think, but you understand that there is a distinction between CNN Inc. and another company called CNN Worldwide, correct?
I know there's a brand called CNN Worldwide.
Right.
On our part, it's not one of the defendants here, but there is a brand called CNN Worldwide.
Right. And you went right to the heart of my question. The defendant here, you know, is CNN Inc., right?
That is my understanding, sir, yes.
Right, not CNN Worldwide.
Correct.
So CNN Worldwide's numbers aren't the right ones for this jury to consider, correct?
I'm not considering them.
Right, you're not considering them.
No,
Okay,
they're not the defendant.
thank you. Sir, it's true, you probably said this, and I'm sorry if I missed it, but what would you consider yourself an expert in?
I do economic damage analysis.
Right.
Both injury, death, punitive damages, contracts. We do damages in litigation.
You're not an expert in the media industry, correct?
No.
And as far as you can recall, this is the first time you've ever analyzed the financial condition of a media company. Is that fair to say?
That's correct, yeah.
Would that be the same for a broadcast or cable network? As far as you recall, you've never previously analyzed the financial condition of a broadcast or cable network?
That is also correct, yeah.
Notwithstanding all of that, you do have a general sense that the cable industry is facing a challenging economic environment at present, correct?
A lot of businesses face challenging economic environments in this country, sir.
Well, sure, but I'm actually specifically focused on the current economic trends facing the cable television industry. You are aware that there are significant negative trends facing the cable television industry, correct?
They do have economic challenges, yes.
Okay. One of the things you would agree that's happening is people are cutting the cord, right? They're cutting the cord. They're not getting cable as much as they used to.
Yes.
And another one of these headwinds that's happening in the cable industry is competition from the streamers, right?
Well, usually they cut the cord and
they get
go
the
to
streamers.
streamer, yeah.
And they get the streamers? Yeah. And so fair to say that you didn't take into account any of these industry trends when you came up with the numbers that you provided to this jury. Is that fair to say?
No.
That's not fair to say?
No.
I looked at your report, and I didn't see any analysis of kind of the headwinds that CNN is facing. Where would I look to find those in your report?
What you'd look to is you would see that the revenue numbers, which are the ultimate telltale sign of any adverse economic conditions. If you look, 2021, 2.2 billion. 2022, 2 billion. 2023, 1.8 billion. Yes, there is a downward trend. So we have taken that into consideration. It's not being done in a vacuum.
Okay, so you went to exactly what I wanted to talk about. So again, let's talk about revenue. Purely focus on revenue, which is the money coming in, not accounting, for the money going out, right?
That's correct.
So what was CNN's revenue in 2021?
$2.2 billion.
2.2. And what about 2023?
1.8.
And what is the percentage decrease from 2021 to 2023?
Over 20%.
Over 20%. So pretty significant decline, correct?
It is.
Let's talk about net income. What was CNN's net income number for 2021? And sir, if you are referring to something when you provide that information, please just put it on the record, what you're looking at. I can give you a report if it will refresh your recollection. There's just certain things we need to do when you testify.
Sure. What I'm referring to is the PowerPoint slides that everybody saw, which are based on the tax return documents from CNN Inc. So, could you restate your question, please?
Sure. Would it be helpful for you to actually, do you know the numbers that you're testifying about, or have you been just looking at your report? I can show you your report if you need to be refreshed.
I'm looking at the PowerPoint slides, which are based on the numbers that were in the report. So the identical numbers. Do you need the Bates numbers for the documents? I don't understand.
So my question is, can you testify just from your memory, or do you need to have your report up?
Oh, I like to have the report. This isn't a memory test.
No, I completely agree. That's why I wanted to show it to you. I actually don't have that deck. Do you mind putting it up? Thanks. And you'll forgive me that since I don't have the report, I'm just going to have to kind of go to the right page numbers.
Counsel, it's in the slides, the PowerPoint slides that were up there that everybody saw. That's all I'm looking at. I'm not looking at the report. I'm just looking at the PowerPoint slides that everybody saw.
Yeah, that's what I'm talking about.
Okay.
We're on the same page, sir. But whatever.
Mr. Axelrod, you want my copy?
I have an old copy. Thanks so much. So just bear with me. Yeah, I'm trying to jump to just the right slides. All right. Yeah, so if we could go to slide. Are there page numbers on here? Corey, thank you for helping me out. If you could go to the net income number. Thank you very much. Appreciate that. So, Mr. Johnson, what was CNN's net income in 2021?
Net income for tax purposes, $6 billion. 0.6 billion, effectively $600 million.
And in 2023?
It is approximately 0.4 billion, 400 million.
And so what is the percent reduction from 2021 to 2023?
About 50%.
What's that?
About 50%.
50%?
Yeah.
Okay. Pretty significant?
Yeah.
And then finally, if we could go to the next page, Corey. This is the net worth.
I misspoke. About a third.
What's that?
Third.
It's a third?
A third. Yeah.
Okay. I think maybe you were jumping the gun. So at the net worth number, what was the net worth number in 2021?
4.4 billion.
4.4 billion. And what was the net worth number in 2023?
2.3 billion.
So what would be the percentage decrease from 21, 23 in CNN's net worth?
It's cut in half.
Cut in half. So you would agree that just looking at these numbers, that those negative headwinds we were talking about, they're showing themselves in CNN's financial data.
Correct. Yeah.
Thank you, Your Honor. I have no further questions.
Redirect.
Just a few more questions for you, Mr. Johnson.
Okay.
Mr. Axelrod said you've never analyzed a media company before. You remember that?
Correct.
So what kinds of companies have you analyzed?
let's see, I've done tobacco companies, I've done drug companies, I've done baby powder companies, I've done aircraft companies, I've done airlines, I've done beer companies, I've done people who build tour buses for the rock stars. So I've done all kinds of companies. This is the first media one.
All right, and can we put the net income slide back up, Corey? All right, so Mr. Axelrod was asking about this slide, right? And I think you said there's a 50% decline from 2021 to 2023?
Correct, I misspoke, it should have been. It's only gone from 0.6 to 0.4. That's about a third, about a 33.33%.
So 0.4, how much money is that again?
That's 400 million.
And net income's profit, right?
Correct, that's after-tax profit.
So it went down and they still make $400 million?
Correct, yeah.
And then earlier you gave an example about when your kid does something wrong and you gotta put them in timeout or put their allowance in timeout.
Objection, outside the scope of cross.
Oh. I don't know what the question was alluding to. It may be related, so let's hear the question.
Fair enough.
So Mr. Axelrod also asked you about revenues, right?
That's correct.
I think he said that from, I don't remember which years he was talking about specifically, but that there was a 20% decline in revenue.
Ballpark, yeah.
Can you remind me, what is CNN's average revenue per day?
Oh, ballpark, 5 million a day, 4.9, 5 million a day, average revenue.
Okay, but it's gone down 20%, you said.
Yeah, that's after the 20%.
Okay, so it's about after the 20%, now there's still 5 million a day?
Ballpark, 5 million a day, correct, yes.
So if this jury wanted to punish CNN, like let's say the jury wanted to put CNN in a timeout for 30 days, can CNN afford that?
Yeah, I think they could.
Yeah?
Yeah.
So what's a 30-day timeout? How much is that?
Well, at 5 million a day, 10 days is 50 million. 3 times that, 30 days, is 150 million.
Thank you.
Jurors, you have the opportunity to ask Mr. Johnson questions. Jot them down if you have the questions. Otherwise, obviously, just tear out a page in your notepad and hold it over and pass it to the bailiff. No juror questions. All right, Mr. Johnson, you can step down.
Thank you, Your Honor.
Would plaintiffs, your next witness would be?
Our next witness would be Mr. Cohen, Your Honor.
Come. Have we gotten anywhere on a resolution?
My understanding is that a new set of definitions is being worked on right now.
A revised down one?
Yes, Your Honor. I've tasked people with getting it as short as possible.
All right.
maybe just like a 3-minute, 5-minute break might be productive.
Let me, and because I wanted to address the other issue too. Why don't we do this? We'll have the jury retire back to the deliberation room for the moment. Go ahead and leave your notepads on your chairs. While you go back, I've got to make a ruling on one issue real quick, and we're trying to address this other issue. So just leave your notepads here. It should only be a couple minutes, but again, let me give you the instruction. Remember, all the rules I've given you apply even when we're outside the courtroom. Remember the basic rule: do not talk with your fellow jurors, friends, family, coworkers about anything having to do with the trial except to speak to court staff. No emailing, text messaging, tweeting, blog, or other form of communication. You cannot do any research about the case or look up any information about the case. And remember to observe all the other rules I've given you. If you become aware of any violation of those, please let court personnel know. And again, I'll remind you again, even though you've already started deliberating and doing those things, don't have any discussions regarding the trial while you're back there for right now. All right, so we'll see you in just a couple minutes. Right, the jurors are out of the courtroom. Y'all be seated. All right. On Dr. I was going to ask to resolve the issue. Do you have a problem, and just to keep going and getting done, do you have a problem? I'm going to allow Dr. Janesha to testify with a condition here in a moment, but do you have a problem of putting her on the stand and going now while you're still working out Mr. Cohn's?
No, Your Honor. I think that makes a lot of sense.
All right. Are you guys okay with that?
I think that's fine.
Fine. Okay. All right. In terms of the objections on the motions in limine, I think she's qualified to testify. I think she's qualified to point out the issues that are there. A lot of the issues you've raised, Mr. Delich, I think you can deal with on cross-examination with her, and it goes to, again, the assumptions or positions or biases or any other credibility issues that you can attack on cross-examination. The one issue, and I think some of it's borne out by the actual factual data, but the one issue where I think there's an issue, and I really see it as more of a relevance issue, is she talks about some of these things going out to 2028 and things of that nature, and I don't know that that is the analysis. And that goes to the trend issue, which was brought up on cross-examination of Mr. Johnson. I think it's fair game for her to talk about the trend, and to the extent that it's consistent with what was in that S&P or the Kagan data or whatever, I think that's fine. I think the projection aspect of it gets into a relevancy issue. So therefore, I think Mr. Tobin, she can testify about everything that she testified to. With the relevant inquiry is the valuation, ability to pay now, not 2028, not 2030, not 2035, whatever. So, and she can talk in reference to the Kagan. I think it's at least authoritative enough, as it may back up and comport with what she's saying of the trend line for the last 3-4 years, that we have the data that was exchanged between the parties. But for her to opine that, well, this is going to continue into the future, and I've got this report that says so, and doing a projection or a suggestion of what the future, either the revenue numbers are, the net income numbers are, or the valuation numbers are, maybe after 2025, I think that's a problem. To the extent we only had hard data through 23 on like the tax returns or whatever, obviously I think she can say, well, bringing us forward to January of 2025, assuming this trend line that's backed up by the Kagan data, that's fine for her to opine on for valuation purposes, income purposes, and those sorts of things as of today. But we're not going to talk about post-January 2025 trending. Okay. All right. Just to articulate, Doctor, what I'm ruling is the relevant inquiry is what the valuation is as of today, the ability to pay as of today, and those sorts of things. Some of the things you talked about in your report had to do with, I looked at the Kagan data, and I was projecting out we've got this trend line going down, and therefore in 2028, we're going to continue at this rate, or whatever, or the percentage decreases over that time. That's not necessarily the relevant inquiry for today. So you can testify about what you have in your report and your analysis and the points that you raised about what the documentation showed that you're saying Mr. Johnson may not have taken into account. But in terms of saying that there's a trend line and in 2028 it's going to continue to decrease at 20%, 30%, whatever it is, I'm reining that in to not talk about projections after January of 2025. All right. To the extent that you're using the Kagan data to go from the last hard documentation and data that we have from maybe 2023 to say, well, he didn't have the numbers for as of today, but based on this, January, the net value would be decreased by another 10%, or the revenue number would be decreased by 10%. That's fine. But we're stopping as of January 17th. I don't even remember what day of this. But we're stopping as of today. Do you understand? So we're not going to talk about future projections.
Yes, I understand.
All right. And the only reference to the Kagan stuff is as to get us to today. And whether it backs up the actual hard data that's in the numbers that were used, or it gets us from the last hard data that we have to today, that's fine. All right?
Ron, I did have one related issue. Dr. Janesh's office prepared a demonstrative. Council had agreed to it, but it does contain in shadow projections out past 2025. I don't know that we can cut it.
Do we only have it in PDF, or do we have it in PowerPoint? We don't have it.
So,
Put a box over it? Yeah, just like that. Yeah.
Just do like a redaction box?
Yeah.
Yeah, if you can do that, that'd be great.
if we could just have a couple
All right.
minutes to get that.
And Your Honor, unfortunately, I think I got out in front of my team on the issue of Dr. Janeja testifying before Adam Cohn. Apparently, some of the numbers, if his relevant testimony comes in, Dr. Janeja will provide context to some of the numbers in the Cohn testimony. So
Probably need that.
sequentially, he would have to come first.
All right. And Mr. Cohn, I'd allow him to testify despite the fact we didn't have the designations. I've got two things. I mean, one of them is obviously if there's an objectionable question that he shouldn't be testifying to, it shouldn't be testimony that's played to the jury. The second aspect of it is from a timing standpoint, let's, to the extent that we can minimize duplicative testimony between Mr. Cohn and Mr. Johnson, that's just a timing issue.
Can I make two broad points about his testimony?
What's that?
Can I make 2 points?
Yeah.
The first point is you heard Mr. Johnson testify a second ago that the CNN worldwide numbers aren't the right numbers to be in this case. Almost all of Mr. Cohn's testimonies about CNN worldwide, by their own admission, those aren't the numbers we should be talking about.
But one part of the problem is all they were getting was CNN worldwide numbers?
He did an analysis. He stood in court under oath and said this 2 point, I don't remember the figure, but the CNN Inc. number is the right number. They've already, through their expert, admitted that the CNN worldwide numbers aren't the right ones. Almost all of Cohn's testimony that designate is about CNN worldwide.
Okay.
Your Honor, to the extent we want to, I may be able to address this concern for some of the designations. I just been a little on the fly here. I've been able to get back in and see what we can cut. I do think that there's probably a substantial amount of material that can get cut from here if I could have, 5 or 10 minutes to take a look. It's just
who's dealing with Dr. Janeja's cross?
it's supposed to be Mr. Friedman. So if he can't be found, I would step in. But the plan was for Mr. Friedman to handle that. Although it sounds like she can't go until we figure out Mr. Cohn. I think if I could have 5 minutes to figure it out and another 5 minutes to try to make sure things are worked out with Paul and Corey.
I just want to make one other broad point. Most of the designations or a significant amount involve things like, well, you don't have a balance sheet, you don't have this, just building an evidentiary record for discovery type issues. Mr. Friedman earlier, when we were going over this, in saying those are relevant, said it's relevant because appellate courts have said that we agree. We've got an appellate record on that. That has nothing to do with the trial. They want to, if there's a post-judgment appeal and they want to make an argument about we didn't meet our burden based on this and that, they've got that record. They don't need any trial testimony. That's the deposition and that's the discovery. So that would not be a reason to bring any of that in. The only purpose is just to embarrass the indictment, and it's prejudicial.
Well, I was thinking about that from the standpoint of you will consider his filing of his deposition, which it probably already has been filed, but if not, but if that resolved the appellate concern issue or a remitted issue or whatever, new trial issue, what have you.
His full testimony has been filed with the court.
Okay.
It might, Your Honor. It might. That's the best I could do right now. I don't want to overcommit here, but I do think that with just a small allotment of time, I can get this down to probably just a couple small clips.
Well, let me ask this more fundamental question, because Mr. Axelrod was saying the problem of Dr. Janajan testifying right now is you needed to get some Mr. Cohen stuff. If you guys were fighting about using Mr. Cohen's depot, if Mr. Cohen's depot wasn't used at all, is there an issue with Dr. Janajan testifying?
There's testimony that they like that we think she can provide context for. So we think we should follow the sequence in a world in which Cohen is.
Oh, you're saying, so if the testimony comes in, then you'd have her testify about certain things. I got you. Not that her testimony needs Mr. Cohen as a foundation.
Not at all.
Okay. Okay. All right. Mr. Dell, see if you can square away with Mr. Cohen's stuff.
Yes, Your Honor.
Just a couple minutes ago, I got a note from one of the jurors that asked if they can text their mother to see if she has a ride to work. And obviously we need to talk to them, and there'll be more than a minute or two. Are you okay if that juror goes? The phone's probably out in the jury lounge?
Yes.
Okay. All right, how do you want me to bring him in?
I think you just, any way you want to communicate, it's fine. However, the fastest and most efficient way is fine.
Why don't you grab that juror and tell them to go run out to go do what they need to do on their cell phone? Note, didn't bother to bring it. I know there were some attorneys still in the courtroom, but the note earlier said, "Hi, did you forget us? It's 5 o'clock somewhere."
Jurors entering?
And y'all may be seated. I did not forget about y'all. However, as sometimes comes up in the course of a case, there's estimates of amount of time that things may take to get worked out or deal with, and sometimes they take a little bit longer. But your patience by being back there was actually a fortuitous thing, and your participation over the last 2 weeks has actually been a beneficial thing, because the parties have reached a settlement of the remaining part of the claim. So you will not need to hear any further testimony. You will not need to go and deliberate any further. And we've concluded the trial. So your patience in my few minutes, I think, or whatever it was the first time or second time I said 15 or so, it ended up being beneficial to the parties. So, you all have been here for 10 days. You paid close attention. You've asked some great questions throughout the course of the trial. You all spent a long time late into last night and this morning deliberating the case. And I can tell you on behalf of the court, I appreciate it. It's definitely on behalf of the parties. They both want to express their appreciation to you. You know, sometimes parties can work things out, talking amongst themselves. Sometimes it takes necessity of getting here, presenting a case, putting on witnesses, putting on evidence in front of y'all, hearing the things that you're asking them. And in this case, obviously, you deliberated part of the case, but it's a beneficial part of the process of parties sometimes being able to work it out. So, and they have told me when they came back and announced that they reached a settlement, they told me that being here and having y'all give us your time and attention for the last 2 weeks was an important and a big part of assisting them in getting to that sort of resolution. So don't feel like your time was wasted, because it was very beneficial from the standpoint of getting this to a conclusion. Now, having said that, I'm at a point where I can discharge you from your service as a jury. I want to tell you that on behalf of the parties, the lawyers, and the people of the state of Florida, I wish to thank you for your time and consideration in this case. I also wish to advise you of some special privileges that you enjoy as a juror. No juror can be required to talk about the discussions that occurred in the jury room except by court order. In other words, nobody can come up to you and force you to talk about anything you thought about the case, any discussions you had about the case, unless you get an order from me that says you need to come down to the courthouse and tell me this because of some issue. For many centuries, our societies relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to talk about your work as a juror in this case. The lawyers and their representatives are not permitted to initiate any communication with you about the trial. So they know, as officers of the court, they're not to reach out to you and contact you or try to ask you anything about your thoughts on the case and the trial here. However, you may speak to the lawyers or anyone else about the trial. I've been telling you for 2 weeks, don't talk to anybody. At this point in time, you are free to talk to whomever you want, but that is up to you. You also have the right to refuse to speak with anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. However, it will be up to you to decide whether to preserve your privacy as a juror. So rest assured, nobody can force you to talk to them, but it's entirely up to you, and you are free to talk to whomever you do and choose to at this point in time. Your notes? Yes, ma'am.
Oh, I just wanted to say that this jury has been, they've been wonderful to work with. They have taken their job, we have taken our jobs very, very seriously. We had some excellent discussions and questions and tossing about in order to reach our decision. And I think that they are just, I just want to say how much I enjoyed working with them and with you as well.
No, I appreciate that. But I know that you guys had some good interactions. Y'all got and obviously spent a lot of time over the last 2 weeks together. So, I do appreciate it, and the parties definitely do as well. At this point, your notes, are they still back there? Or they're on your chairs, aren't they? Yeah. Go ahead and leave your notepads in the folders. My bailiff will collect those, and we're going to destroy them. No one is ever going to see your notes. The bailiff out there's got a little note for you. If for some reason you do get summoned for jury duty in the next 12 months, you get out of jury duty free card. Hopefully that won't happen, but if somehow you do, you've got the note there, and you can contact the clerk's office and tell them that you should be excused, unless you want to come back and do it. That's entirely up to you as well. I will tell you that we did not, on jury selection last Monday, none of that was streamed. So the fact that we used names or whatever, there were no images, no names or anything. During the course of the trial, the media has been careful that nobody was picked up on the video for any of that, or if accidentally something happened, it's been immediately blurred or removed. Even my boo-boos, which I caught myself once, well, I think it was 3 times total. They have removed any names that I may have accidentally used during the course of the trial of any of the jurors in the case. So your identity is not, has not been out there. And I do appreciate the media's cooperation and assistance with that. So I think one of y'all may have been kind of curious or something about that at one point. But anyway, just to let you know, that is that. Anybody else have any questions or anything? Yes, ma'am.
Do we have the privilege of knowing the settlement amount?
I don't even know. I don't know.
All right, I'll Google it.
Apparently not.
Be on the front page tomorrow.
Well, now you can look things up if you want to. What I'm going to do is you still have stuff in the jury lounge there, so I'm going to have bailiff take you, get your stuff collected from the jury lounge, and we'll have a bailiff take you down to the parking lot. Oh, yes, I normally. Unfortunately, other than your get out of jury service note, you don't get the juror badge as a souvenir from your service.
There are some notebooks in there.
It's on the table. There was,
Do y'all have anything else back there?
yes.
In the deliberation room?
Yes.
Right here.
Okay. All right. Well, why don't we, if nothing else, y'all have a great weekend. And it is 5 o'clock somewhere now.
It's actually 6 o'clock.
somewhere now.
And I will say I've never had a juror sidebar with the static noise on before, so I appreciate that. And the lawyers have not either. So
Thank you. Thank you, Judge.
thank y'all. Y'all have a great weekend.
We can exit.
Thank you guys for the food. You're welcome.
2 weeks. He was open for a third week.
Is that all of them? Or is there still one back there? Or two?
Almost stepped out, just ran around.
Oh, no, we can. No.
Thank you.
All right, y'all can be seated. Jurors are out of the courtroom. Is there anything else?
Pretty safe question to ask now, Your Honor.
I feel a little more comfortable saying that.
Not for playing.
No, Your Honor.
All right. I guess since there's a resolution of the case, the note that I had last night. I did seal it. For the record, the note we got last night, which was right at about 9 o'clock, when I just had them come back and I said, you guys agreed to stay till 9 o'clock, so and you haven't reached a verdict. Their question was, can we answer question 1 and question 2 tonight and come back tomorrow for 3, 4, and 5? And my fear was it was not disclosing any vote that they had, but it was disclosing potentially where the verdict was going. And obviously until the verdict was reached in the case and decided, they could have gone back and gone and changed their decisions.
Does it have any word or sentiment potentially hung up?
This is very important, Your Honor, because there's some money going one way or the other between me and Mr. Sanborn based on what
I read you verbatim what the note And I guess other than, I said the word question 1 and question 2, it actually said Q1 and Q2.
Have a hard time getting to the other.
So anyway, I mean, obviously it's not an indication of what their decision was on their verdict.
Is that the gist of the note?
The implication. But anyway, so that's why I didn't want to read the note, and I needed to take a moment to decide what I needed to do, since normally we discuss the notes that comes from the jurors with both sides, but I didn't think it would be appropriate under the circumstances last night to do that. So hopefully you understand why I just said, they said they stay till 9, so they're going to go home, and we'll be back in the morning. I do, I said yesterday, I commend both parties and the counsel for the way that the case was presented, despite some of the hiccups and things that have come up during the course of the case. But I do, for the most part, the presentation of this case over the last couple of weeks has been professional and very clean presentations with how you guys have your teams running things. And, it's impressed me. It's, those things are easier. Those make it easier for me sitting up here instead of starting and stopping. And I think in terms of a jury presentation, obviously, I think it makes a big impact of not having the jurors just sitting there while you guys are trying to figure out how to get an exhibit up or something like that. So I think the way that the case has generally progressed, the trial progressed, was great. And in the lead up to this case, your teams, you may have had diametrically opposed opinions on the outcome of a particular issue or whatever, but y'all were very professional in working together generally to try to resolve down and distill down whatever the heart of issues are. So I appreciate that. I also appreciate the extensive briefing that both sides provided on stuff. It was a lot of stuff to read on my end, but it does make my understanding of an issue and my ability to rule on an issue, and hopefully in a timely manner, a heck of a lot easier. So I do appreciate that. And I've enjoyed that. I've enjoyed that aspect of this case of the way that y'all briefed everything. I do want to say I appreciate the cooperation of the media. It's not always the easiest thing. I say stuff that I forget a couple of times, and I appreciate y'all covering me on those to try to protect the identity, especially of our jurors in this case, because, we inconvenienced them enough by having them here for that period of time. Y'all made the comment last night, I think Mr. Sanborn did, about our support staff. And, you see a number of people that have been here in the courtroom, and you've talked with a number of them, but there was a ton of people in the lead up to this between the clerk's office and the security in the courthouse, our IT and court administration staff that really made it possible that things could run smoothly. I know, they worked very well with y'all in the lead up to this so that things could be done. They worked extensively with the media folks. So I appreciate that. And, just me being able to get stuff done on a somewhat timely basis without my assistant and my staff attorney helping on this thing. I want to thank them, obviously, for their help and helping me get through this and try to make rulings that a lot of times maybe you're not happy about, but at least I can get them done where we can keep things on track. So I do appreciate that. I wish everybody safe travels back. Hopefully you don't run into travel issues with the weather, but looks like next week is going to be pretty darn cold in a lot of places that people are heading back to. So unless we have anything else, we'll be adjourned.
Thank you, Your Honor.
Thank you, Judge. Your Honor, if I may, it's just been an absolute pleasure practicing in front of you for the past 2.5 years. We're very lucky to have you on the bench.
I appreciate that.
I know we threw a ton at you, and it was very much appreciated.
Well, I've enjoyed some aspects of it, even when it's curveballs coming out of there. Just because, the challenge of something new, different, and having to deal with it. But, again, y'all's work on stuff has been helpful of prepping things and loading all this stuff into OneDrives and everything else throughout this. So.
I hope Brittany's been getting paid overtime.
I was just going to say, I wanted to just thank Smith for extraordinary attentiveness.
No, that's what I'll say. Without her being able to get stuff back and forth to y'all and get communications and things from y'all, sending me emails early in the morning.
Oh, and the
551 filing for Mr. Delich.
the staff. We've practiced in a lot of courtrooms, and the IT staff is superb.
Yeah, no.
Thank you, Mr. Hagan.
All right, well, with that, y'all have a great weekend. Safe travels. Thank y'all.
Your Honor, go Gators.
You have an interest?
Took it on the chin in basketball the other night, though.
I didn't think